Good evening to one and all present here. I, Dr. Saurabh Verma, Assistant Professor, Department of Management Studies, NIT Silchar, and coordinator of this event, welcomes you all on the second day of 1 week workshop on intellectual property rights and entrepreneurship development. Today we are having with us Professor Rajendra Kumar. Sir is Dean of Student Welfare and Coordinator of IPR Cell in NIT Kurukshetra. Good evening, sir. I welcome you on behalf of organizing committee of this workshop.
Good evening.
Professor Rajendra Kumar is a professor, Department of Business Administration and Dean Student Welfare, National Institute of Technology, Kurukshetra, Haryana. He has served as a professor and head in Department of Humanities and Social Sciences for a period of 11 years and head of Department of Business Administration more than 3 years in the same institute. He completed his PhD in 1984 from IIT Roorkee. He has published 45 research papers in national and international journals. He received the Best Paper Award from the Institution of Engineers for the paper Automation, Its Socio-Economic Impact, a Case Study of India in 1990. He was also conferred Research Fellow by American Biographical Institute, USA, 1990. He has completed 2 research projects on intellectual property rights sponsored by MHRD. 14 research scholars have completed their PhD under his supervision, and I am lucky to share that I am the fortunate one. I have also done my PhD under the supervision of Professor Rajendra Kumar, and presently 2 research scholars are pursuing their PhD. He has organized a number of conferences, seminars, and summer schools in the institute. He has visited various countries like USA, Sweden, Greece, Spain, Thailand, and China. He also delivered a keynote speech in the inaugural session on the topic Environment and Sustainable Development in South Asia in an international conference organized by International Center of Economics, Humanities, and Management at Phuket, Thailand. He presented a paper and analysis of trends and composition of India's trade with BRICS at International Symposium on BRICS at Jingasu Normal University, Shuzhou on October 2016. Presently, Professor Kumar is working on a project
clause, and the two more clauses, the trade in services. So general agreement on trade in services, 13 services were included, and education was one of them. And third clause was TRIPS, trade related intellectual property rights. Now the point here is that the moment this third clause was added as a compulsory clause in the new regime of the WTO, then this IPR laws became very popular, not only in our country, all over the world. So that is the point that we are discussing these laws, and we are discussing with the reference of the business, with the reference of the entrepreneurship, because these laws will affect the establishment of the entrepreneurship and growth of the entrepreneurship. So with this background, now I start my presentation. The topic was given to me, the concept, relevance and forms of this concept, forms and relevance of the IPR. So first I take the concept, the meaning side, that what is the meaning of the IPR. Now you see carefully these slides. Saurabh, am I this audible, and am I okay?
Yes, sir. Yes, sir. Yes, sir. Absolutely, sir.
Okay. So this is the part, this is the concept basically. So here we are having the words intellectual property rights and the IPR. So what is the intellectual? The first word meaning is this is relating to human mind. This is the human intellect, and all we will agree by this statement that the intellect level of all the persons are different. Someone may be expert in one area, others may be expert in other area. Some may be very research minded. So whatever the new things they are having, that the protection will be given to the innovation of a person, the invention of a person, to the publication of a person, that will be given under these laws. So what is the intellectual? Intellectual, this is related with the human mind basically, and the product of the human mind, that will be protected under the IPR laws. Then property, something that one owns or possesses. Say for example, if you have a physical property, it means that you are having some piece of land, you are having some building, then the ownership will be in your name. Similarly, that in case of if you create some intellectual property, like in the book, in the form of a book, in the form of a research paper, in the form of an invention, that this ownership will also go in the name of the owner. So like the physical property, this intellectual property will be in the name of the individuals, that those who will create these properties. Rights means a legal claim. Legal claim means if somebody will try to disturb your rights, that you may take the help of the law of the land, say police and all that side. Suppose you are having your plot, if someone take illegal possession on your plot, your land, that immediately you will go in the court, you will contact the police, and you will get the relief. Similarly, that if someone will try to use your work unauthorized way, then immediately you may go in the court, you may take the legal help. So immediately you will get the help. So what is the IPR? A legal claim guaranteed to the products of the mind, that is rights guaranteed for innovation and invention. So in a very simple way, what is the concept of the IPR? That whatever the property is created through the human mind, this property will get the protection through the legal system of the country. In very nutshell, this is the concept of the IPR. The next part, this is the legal claims. When we talk about the legal claims, say for example, someone has developed a technology and it is marketable, then I wish to use this technology, an entrepreneur, then I may request the person that you give me the license. Then the innovator may provide the license to the person, and person obviously when will get the license, the terms and conditions will be decided by the innovator, and obviously that in the form of the money, the person will get the money, and person may give the license to so many producers, and they may use this technology by paying to the innovator. Sold, the person may say, no, I'm not interested to issue the license, that you purchase it, and the person may sell it, and in lump sum may charge the price. Gifted, it is your property, if you like, that you may give to someone. Inherited means, say for example, in case of the law of inheritance in our country, that the property of the father will be distributed among the children, equally distributed among the children. Similarly, that this, according to this law, the intellectual property may also be inherited to the children of the innovator. Suppose you have written a good book, that the rights that may be transferred in the name of the children. So in very nutshell, this is the concept of the intellectual property rights. I do hope that it is clear to all of you that what is the concept of the intellectual property rights. When we talk about the forms of the intellectual property rights, there are the 7 types of the IPRs. One is the copyright, patent, trademark, industrial design, geographical indications, trade secret, layout designs of integrated circuits. So now I will take one by one. These are very important part, and these forms will help in establishing the entrepreneurship, in establishing the business. If we will violate these laws, that will find ourselves in trouble. First, I take copyright. Deliberately, I am taking copyright because I am sure the most of the participants will be from the academic world. So in the academic world nowadays, that the people are facing so many problems due to the ignorance of these laws. But people are very intelligent nowadays. They will not allow the other persons to use their work. So if you wish to use the work of others, then that will come under these laws. So first is the copyright, because we academicians will be affected by this law maximum. So what is this law? What is the copyright? Copyright is a legal term describing rights given to creators for their literary and artistic works. So 2 types of the work of a person, literary work and artistic works, are covered under the copyright law. As I told in the beginning, that these are the legal entities. Basically, they are having the legal meaning. These are the laws, in fact. So what is the copyright law? Copyright law in India. So I'm discussing the copyright law in India in such a way so that you participants easily can catch the idea. Otherwise, it will be very difficult to understand the terms used in the copyright law. So I'm simply telling you the implications, because only 1 hour is allotted to me. So I will try to explain in such a way so that you participants may be benefited. So obviously that the question you will ask me, the literary works and the artistic work. Literary works, as per the copyright law 1957, we are having the meaning such as novels, poems, plays, reference works, newspapers, computer programs, databases, films, musical compositions, and choreography. This is the definition of the literary work in India as per the copyright law 1957. So this work will be covered under the copyright law. We have the artistic works such as paintings,
Sir,
drawings.
sorry to disturb you.
Okay.
Sir, can you make the presentation full screen, sir, so that we can be able to see it very clearly?
I will try.
Thanks a lot, sir. Yes, sir. Thank you very much, sir. Please continue, sir.
Okay. So I was explaining this artistic works. So artistic works such as paintings, drawings, photographs, and in sculpture we are having the architecture, advertisements, maps, technical drawings. So in literary works that we have the specific work, and in case of the artistic works, we are having the specific works of a person. So paintings, drawings, photographs, sculpture, then architecture, advertisement, maps, technical drawings, all will be covered under the artistic work. And when we talk of the literary works, the novels, poems, plays, reference works, newspapers, computer programs, databases, films, musical composition, and choreography, that will be covered under the literary works. Cinematographic films, which include soundtrack and video film, that will be covered under the copyright law. Record any disc, tape, perforated roll, or other device, that will also be covered under the copyright law. So in very nutshell, this is the scope of the copyright law. This type of the work will be covered under the copyright law. Besides these main activities, there are some other activities also. These are covered under the related rights. So what are these related rights? Performing artists. Performing artists, it means that when someone will do some type of the acting, for example, that his or her work will be covered under the copyright law. The performer's right, basically. Performer's right, say for example, when a teacher teaches in a class, the teacher is the performer. When a person will do some acting on stage, that will be known as the performer's work. So here I am giving one example in one movie that Dilip Kumar, Shah Rukh Khan tried to copy Dilip Kumar. Then Dilip Kumar immediately objected, and the attorney of Shah Rukh Khan told him, "Sir, file unconditional apology. Otherwise, as per the latest copyright law, you will be in trouble." So it stops such type of the activities. Producers of sound recordings, for example, cassette recording and compact disc, that will also be covered under the related rights. And TV programs, this broadcasting organizations in their radio and TV programs, that will also cover under the related rights. That will cover under the copyright, but that will come under the related rights. So this is the scope of the copyright law. It means that the book industry, computer industry, when we talk about the music industry, film industry, television industry, all will come under the copyright law of the country. So why we should protect the copyright? In fact, that in the beginning I have told you that all people are not equal in terms of the intelligence. So some are very good in writing the novels, poems, like that. So the benefit of the work of such of the people should go to the people. They should enjoy. And obviously when they will invest their time, their energy, their money also, that they should be rewarded financially. If they will not be rewarded financially, then they will stop the further works. So that is why we are having so many examples that in the ancient time, there were the various intelligent people like Munshi Premchand. He wrote a number of novels, but copyright law was not effective and he was a very poor person. When we see in English, Shakespeare was very intelligent person. He wrote number of novels, dramas, and his work was also not protected. He was also a very poor person. So nowadays, to stop such type of things, those who are doing their best in these activities, they must be awarded. So this is the reason, so that the people may be benefited by the activities of this person or by the intelligence of the such type of the person. Those who are having the extraordinary intelligence. For example, someone is very good in music, so should develop and people will enjoy the activity of the person. So these are the reasons that we should protect the copyright law. When we talk about in India, this copyright law came in 1957 first time. Then it was amended for so many times, 1983, 84, 1992, 1994, 1999, and last amendment came in 2012. And this is the address, in fact, that earlier it was covered under this MHRD, but now there is a separate cell for this Department of Industry, Policy and Promotion, Ministry of Commerce and Industry, G30 Supermarket, Agast Kranti Bhavan. So this is the address of the copyright law. Rather, all the laws cover under this particular address nowadays, because present government has combined all these laws under one umbrella. That the frequent question that normally persons ask me, can an idea be copyrighted? No, idea will never be copyrighted. According to a survey, a common person gets 20 ideas in 1 minute. So if you get 20 ideas in 1 minute, that how the ideas may be copyrighted. So idea will never be copyrighted unless this idea is converted into a form of the novel, into the form of a book, in the form of a drama, in the form of a poem. So this work will be copyrighted, but idea will never be copyrighted, or ideas will never be copyrighted. When you see the term of the copyright protection in India, so now you just listen this carefully, that in our country, throughout the life of the author, the copyright protection is enjoyed. And after the death of the author, up to 60 years, these benefits may be enjoyed by the family members of the author. It means that it is inherited. Inherited means that after the death of the person, the children, grandchildren of the person may enjoy the benefits of his or her work. That is why Gandhi Nehru family got huge royalty on the work of Pandit Nehru and Mahatma Gandhi. Recently, that this Rabindra Bharati University approached the authority that you enhance this period also, because university is getting huge grant, huge money by selling the work of Guru Rabindranath Tagore. So, but anyhow, this is the law throughout the life of the author plus 60 years. In case of copyright in cinematography, films, records, photographs, posthumous publications, anonymous and pseudonymous publications, work of government and of international organization, the term of protection is 60 years, and that will be counted from the date of publication. In case of broadcasting authority, the time is the 25 years. It means that the TV serials, the life is 25 years, not more than 25 years. When we talk about the musical work, dramatic work, that you persons may not be affected by this. So that is why deliberately I'm deleting all these slides. Otherwise, that I have to shortcut my presentation. I'm only talking about the relevant side. Otherwise, this law is also very wide, and time is too short from this angle. So, can any person translate a work without the permission of the owner of the copyright in the work? No. The answer is no. A person cannot translate enjoying copyright without the permission of the copyright owner. Say, for instance, if you wish to translate Hindi into English, English to Hindi, Hindi to Urdu, or English to Urdu, this is completely prohibited unless you get the approval, the permission from the original owner. Is there any copyright over news? No. The aim of the news is to disseminate the information among the people, but the way, the method that the news reader style, that will be or come under the copyright law, because the style of every person, the news reader, is different. Say, for example, Deepak Chores has his own style, Rajat Sharma has his own style. So, style of these two of such type the persons will not be copied. That will be covered under the copyright law. That will come under the related rights. So, nobody thought that in future that this copyright will give the protection to the industries. So as I have told you, that it means that the book industry, music industry, film and television industry, computer industry, database industry, that will be covered under the copyright law. Are computer programs protected under copyright? Yes, as per the 1984 amendment, the rights in a computer program as a literary work. So these are covered under the copyright law. How is computer defined for the purpose of copyright? There is a specific definition. Computer includes any electronics or similar device having information processing capabilities. This is the definition of the computer as per the Copyright Law Amendment 1984. What is the definition of a computer program? There is a specific definition of the computer program, means a set of instructions expressed in words, codes, schemes, or any other form, including a machine readable medium capable of causing a computer to perform a particular task or achieve a particular result. This is the definition of the computer program. Can software be protected through copyright? Yes. Software may be protected under both of the laws as per the latest amendment in the patent law, under the copyright law also and under the patent law also. But what is the difference? The difference is, say for example, if we develop the software separately, if we download the if we upload the software in computer separately, on laptop separately, that will come under the copyright. That is why when you will operate your computer, your laptop, that will find the copyright. But if it is inbuilt with the hardware, that will be covered under the patent law. So this is the difference between these two. Can copyright be a useful form of protection in biotechnological inventions? Yes, because database covers under the copyright law, not so the most of the inventions, not all the inventions of the biotechnological, but some inventions of the biotechnological where huge database is required, that will be covered under the copyright law, because database comes under the copyright law. If an employee in a company develops a program, would this employee own the copyright? No, unless the person is having some contact with the employer. Otherwise, first right will go to the employer. And nowadays, when the appointment letter will be issued by a company, that company will mention the terms and conditions of the IPR, and the person in advance will come to know that whatever the new work he will or she will do, that will be under the privilege of the owner, the employer, not the claim, not will be claimed by the employee, unless the employee has some contract with the employer. What is the rule for the transfer of copyright? So this is very simple, that it is the property of an individual. So individual may allow a particular part of the country, the whole country, free of cost, may charge some price or for the full term also, for part term also. So suppose you are having your land, so you can sell partially, you can sell fully, you can give someone in the form of the gift. So this is the same rule that will be followed here. How much of someone else's work can I use without getting permission? Very, very important when you write a book, when you write your PhD thesis, when you write your research paper, then you will find such type of the problem. So under most national copyright laws, it is permissible to use limited portions. So it may be 5 words in continuation, it may be 10 words in continuation, and we do not have uniform rules for that purpose. It differs from country to country. That will depend on the copyright law, including quotes for purpose. But the important side, most importantly, don't forget to give the quote. Suppose you are say the borrowing 10 words, 15 words, you borrow it, no problem. Without giving the quote, you will be in trouble. But if you give the proper quote, it means that you are safe. Is a television format protected by copyright? Yes, that will come under the related rights. Is a character protected by copyright? You know that when an author will write a novel, a book, a drama, that will develop some characters. Listen this carefully. Will develop some characters. So these characters will also be protected under the copyright laws. For example, in Sole film, Basanti, Gabbar Singh, these were the characters which were created by Salim Javed. So these characters are the property of the Salim Javed. Nobody can borrow these. Nobody can copy these. So Ram Gopal Verma tried to produce a film following copying the Sole film, that immediately when Ramesh CP came to know, he objected and he said you cannot do that. And he was stopped to produce such type of the movie because he tried to copy Sole film. So he said, no, I will not allow, this is my property, like that. And not only the characters, even the dresses of the characters are also covered under the copyright law. It is very serious law. If you have seen the movie, I'm sure that most of you have seen the movie Bunty and Bubbly. It was released in 2006. The heroine of the movie that was Rani Mukherjee. So what happened that time? There were the two persons. One was the costume designer, another was the dress designer. So both they were in dispute. That one person tried developed a very good dress for the heroine of the movie. Then the other person said, no, sir, that I have developed this dress. But Akai Verma said that no, sir, I have purchased it from the this football market from the Bombay. So both they went in the court. So this law is so serious. Not only the characters, even the dresses of the characters are also covered under the copyright law. That a little bit, I will devote some time to this. What is the plagiarism? Because most of you may be affected, or some of you may be affected by this problem, or those who will publish the papers in future will write the PhD thesis, that they should be very careful about this. Very simple definition you will find: wrongful appropriation and stealing and publication, see carefully, of another author's language, thoughts, ideas, or expressions. There are the 4 words, but these are very wide words. Language, yes, language. You may say, sir, I have changed the language. No, even that you will be guilty. Thoughts, if you have borrowed the thoughts from others, copied that will also the punishment. Ideas, that you may not say this, sir, this is my idea, because you have copied the idea of others. Or expressions means that whole film industry comes under this law, this plagiarism. This another definition: close imitation, the representation of them as one's own original work, that will covered under the plagiarism. So this is the definition of the plagiarism in very nutshell. Which are the common copyright infringement? In fact, that I'm giving you in a very simple way. Let's say, for example, nowadays, if you go in the library and if you ask some photocopy, that they will say, sir, 1 or 2 pages you can do, but will not allow in quotation 10 pages, 15 pages, or 1 chapter of the book. They will deny you. They will say, no, sir, we will not do that. The reason is that here, that you can copy a book also, you can copy a research paper also, that will make no difference. If you are doing for academic purposes, suppose you are doing your PhD, you are writing research papers, and if you are downloading this work, absolutely nothing is wrong. But the problem will be that after downloading this work, you will compile it and you will go for the commercialization of this work. That is highly objectionable. You cannot do that. If you do that, you will be put on the wrong foot, and severe punishment will be given to such type of the person. So avoid such type of things. For example, say you wish to purchase a book from the market. Book is very costly from the foreign author. Then the publisher is also belong to the other country. The book price may be 5,000 rupees. That your mind will work, because when the mind is very fertile, that what we can do, that okay, why I should pay 5,000 rupees? It contains only 150 pages. If I get it copied, it takes hardly, say, the 200, 250 rupees. You can do that. It is okay. Nothing is wrong with this also. But another step you may take, and you may decide, sir, what is wrong with this? If I will do that job, if I will do this business, after getting colored photocopy of this book, after binding it, if I sell in the market, it means that will, due to this activity, loss will go to the author abroad, publisher from abroad. So these activities are completely prohibited in copyright law. If someone will do this, that immediately action will be taken against such of the persons. We are having say the number of examples also. So today I am not able to discuss all this in detail. So is copyright infringement a criminal offense? Yes, it is very serious. It is a criminal offense. What are the punishments for a criminal offense under the copyright law? So punishment is very severe: 50,000 rupees fine, 6 months jail, and if it will be repeated, that the punishment will be double. But financially, this punishment is nothing. It is very serious law that we are having, so some serious implications of this law. So I'm telling you these serious implications, and by seeing this through such type of the punishments, that you will agree that we should not involve in such type of the activities. That these are the case history, in fact, but today I will not able to quote these case studies. That showed chori ke मामले में Dr. Punya को दी जबरदस्ती, that his fault was that he published the research paper in his own name, and the punishment was given to him, that he was asked for the voluntary retirement, and by force he was retired also. Then Chetan Bhagat, you know the face, when this 3-Jet movie was released, produced by Amir Khan, Chetan Bhagat objected and he said, sir, this is my story, I wrote this story and you have done this. Amir Khan said, okay, no problem, that what has happened, it is happened, and now you can stop the release, but what are the amount you require? You ask me the amount, and he paid him the amount and he kept quiet. And he also asked him that if you are having more novels, also give me these novels, your story, that I will make some more films also. So one person, one lady asked Chetan Bhagat, that you are established author here in the film industry, that she gives some comments, good comments on my work. Then what he did, she gave stories to him. Then what he did, that he stolen one story and he published from his own name. Then the lady went in the court, and now he is facing this problem also. So this is the story, different story, that Delhi University reader was sacked due to the fake research. So in detail, I am not able to cover this today. Now that ex-vice chancellor of the Delhi University also sent to jail for plagiarism. What he did, that he simply didn't recognize the name of his co-author. That was the problem, that he didn't agree. He acted as the vice chancellor for a period of 5 years. After that, he came back in his lab, and the work he did, the work was done by his colleague. He simply asked him, sir, give my name, but he didn't acknowledge his name. Then he went in the court, and punishment went to the former vice chancellor of the Delhi University. Then I am not able to discuss this because it is very lengthy. And it is not the country phenomenon, national phenomenon. It is at the international level also. In China, such type of activities were happened, and this Chinese university also took the very serious action against the professors, the teachers who were involved in such type of activities. So this is about this Google, Amazon, these sites. These are involved in such type of activities also. And then we have these 3 figures. These are very important figures. You recognize these two. Former, one is the former president of USA. One is the president of Russia, and this is the person, Joe, this Biden, that you are aware about this name also. These 3 persons were also involved in such type of activities, and they also go to the punishment. Then which you can download from the UGC, because due to the shortage of the time, I am not able to discuss all this in detail. And only to discuss one law, here we spent 30 minutes, more than 30 minutes only to explain this, because most of you will be affected by this. And the second law, this is the patent, this is also equally important. Now, you just listen carefully about the patent law. It is also a legal entity, it is also a law. A patent provides property rights to an invention. And now you'll ask me that what is the invention? An invention may be defined as a novel idea which permits in practice the solution of a specific problem. So what is the invention? There is no need to have the tension about the invention. Invention is a very simple thing. It means that it is the new novel idea, the new idea which permits in practice the solution of a specific problem, which will give the practical solution of a specific problem. So now here the point is, in a very simple way, nowadays the problem that the country wise. So presently, if you see the basic problem, the main problem the whole world is having about the coronavirus. This is the problem we are having worldwide. Try to understand what is the invention. Scientists all over the world are trying very hard to find out the solution, practical solution of this problem in the form of the vaccine. The person, the country, group of the persons who will invent first, who will give the solution of this problem, will become the invention. And the persons who will invent this, they will get huge money. So you can understand that presently the problem is the coronavirus. Now, who will give the novel idea, who will produce the medicine, which will give the practical solution, which will give the treatment, this permanent treatment of this problem. The person who will invent this will become the innovator, and patent will go in the name of a person or in the name of the number of persons who will work in a person.
Sir, are you there? Sir, are you there? Dear participants, sorry for the disturbance due to some technical errors. Now Professor Rajendra Kumar is joining again. Please wait for a moment. Thank you. Yes, sir. So now we can see you, sir. Sir, you may start your presentation again.
Okay. So sorry for the disturbance due to this power failure. There was some problem with the presentation. So okay, that again, it is all right now.
Yes, sir. Yes, sir. Sir, absolutely fine, sir. Sir, you are audible. Sir, you may start your presentation.
Okay. So I continue this. So if we see this patent, you have go to the idea. It means that protection will be given to the inventions and innovations of a person. In the case
Sir,
of
sorry for disturbing. Sir, your
hello.
presentation is not visible, sir. Sir, kindly share your presentation and make it full screen, sir, please.
Okay. So it is okay.
Yes, sir, absolutely fine, sir.
Okay. 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 So I'm sorry for the disturbance due to the some power failure. So anyhow, so you had understood the meaning of the invention, and the protection will be given to the inventions and innovations by the patent law. Literary work and artistic works were covered under the copyright law, but inventions and innovations of the person will be covered under the patent law. So the terms and conditions to get the patent, we are having the three conditions. It must be new. It means that people should not aware about this work. If they are aware, that patent will not be granted. Involve an inventive step. Sometimes you will find that okay, it is new, but the what person may do the mistake may not include the inventive steps. So that will be assessed. If inventive steps are not there, then patent will be denied. Capable of industrial application. Very, very importantly, that the work should be industrially applicable. If it is not industrially applicable, then the patent may not be granted. So these are the three conditions basically that will be fulfilled by the patentee. One is it must be new, it must involve an inventive step, and it must be applicable for industrial application. Then patent will be granted. And nowadays, as per the amendment in the law, both products and processes will be patented. So you are aware about this, that to produce a product, there may be 2 processes, 3 processes, 4 processes. Now process will be protected as well as the products will be protected under the new patent law of our country. The products or processes to be excluded from the patentability are one, an invention which is frivolous or contrary to well-established natural laws. So that will not be protected under the patent law. Invention contrary to law or morality or injurious to public health. So it may be when we talk about the cigarette, tobacco, when we talk about the wine, the alcohol, all are prohibited. Plants and animals other than microorganisms. So it means that the plants and animals will not be protected under the patent law other than microorganisms may be protected under this law. So plants and animals, that we may not say that because in 2000 there were so many controversies. Very quickly I'm covering it because that time that there was the news that US has patented neem, brinjal. So it was not so. Because these are the plants, these may not be protected. India may not claim that neem is ours or this patent is ours, this turmeric is ours, like that. We may not say like that. Because these are the natural products and these products may not be patented. Microorganisms may be patented. However, where a country excludes plant varieties from patentability, it is expected to provide protection under. So when we talk about this side, this is the agriculture side. Basically, our economy is the agro-based economy. That all the plant varieties may be protected So a sui generis system. So this WTO gave two options, because when we talk about the IPRs, that these laws are covered by the WIPO, World Intellectual Property Organizations, and WIPO is working under the direction of the WTO. So here that WIPO gave two options. Okay, that one, you may have your own system, you can develop your own system, or you must follow UPO conventions on the protection of new varieties of plants. So there was a convention to, and the system was developed, system was given to protect the new varieties. But this was, the Indian government said, no, okay, we will develop our own system. So when government decided, then government immediately formed a law and passed it by the Indian Parliament, the Protection of Plant Varieties and for Farmers' Rights Act 2001. It was enacted in India to protect the new plant varieties. So we have developed our own system to protect the farmers' right, and the terms of protection in India, that is 20 years, and this term will be counted from the date of filing, not from the date of the grant of patent. So 20 years will be counted from the date of filing. And another important point here is that when the protection will be given, that the date of the production will be decided from the date of filing, but protection will be given by the date of grant. It takes 3 years, 4 years, 5 years time, but practically the patent will be granted only 15 years, and it is annually renewable also. If one will not renew the patent after 1 year, that the patent will go under the public domain. So this is a little bit about the these terms of the patent, because I am covering all these very quickly due to some reasons. So what does a patent document contain? If you wish to have a patent, then what type of the things you must have with you? First is the bibliography. Suppose you are writing a research paper, you are writing a PhD thesis, then always first you will do the this survey work. The survey work that includes the review of literature. Through the review of literature, you will come to know that how many people have worked in this area and what is exactly their work. On the basis of this review, and you will find out your own work. Then description, you will give the description of your work, of your research, of your invention. And drawings, if some drawings are required, that you must give the drawings also. Then you have to give the information prior art. Prior art means that this invention was not existing earlier. It was not a prior art in any country or in a particular area of the country. And then you give your current invention. And claims, is the scope of the work, that what is the scope of this work, in which area this work will be applicable. So these information that you can prepare, and these will be required to file a patent. In detail, that if you see, what does a patent document contain? The patent document will contain bibliographical data, abstract of the work. You are aware about this because you are, say, the PG and the PhD. Description of invention. The description of invention involves prior art information, shortcomings in the prior art, complete details of the invention, drawings and workable examples, and list of claims by the patentee. They will give the list of claims. They will mention the scope, that this patent will be applicable. This is the scope of the patent. All these details will be mentioned by the person who will file a patent. Then complete specification that you will mention, because as Saurabh mentioned in when he introduced me, I am working as this coordinator of the IPR cell also. So in day-to-day activity, I am dealing all these things. So the application will contain title of invention, field to which the invention belongs, background of the invention including prior art, giving drawbacks of the known inventions and practices, complete description of the inventions along with experimental results, drawing, etc., essential for understanding the invention, and finally claims. So here I am giving the website also, website of the Indian Patent Office. You may go through this website, and all the details you may get from this. Even through website also you can do that. But importantly, that if you are planning to go for patent, you must have some attorney. Say NIT Silchar has had the attorney, and is giving the facility to all the persons, students, staff, teaching, non-teaching, who wish to file a patent. They can file a patent, and the cost of the patent that will be paid by the NIT Kurukshetra. So such facilities may be provided by some other other institutes also. And during last 5 years, that institute has filed more than 50 patents in patent office, and about 5 patents have already been granted to the institute. So this is the point, because I am handling all these things on in day-to-day activities. So to encourage the persons, to encourage the faculty, and I have developed the system in such a way that suppose if a student wants to file a patent from his own room, he or she can file the patent. So this is the complete specification, and such the activities must be taken up to enhance the inventions and innovations in the country. Then, so these are the in fact 4 offices, because it is pertinent to mention here that in India there are the 4 offices. One is in Delhi, one is in Calcutta, one is in Bombay, another is in Chennai. So these are the 4 offices, and areas are divided. Mumbai office deals Maharashtra, Gujarat, Madhya Pradesh, Goa and Chhattisgarh, and the UTs of Daman and Diu and Dadra and Nagar Haveli. When is the Chennai office, Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the UTs of Pondicherry and Lakshadweep. If you see the Delhi office handles Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, Delhi, and UT of Chandigarh. Kolkata, the rest of India. So I am giving you all these, that in which part of the country you belong, that you will find your area and you contact the office of the concerned area. Say if you belong to, say, the Chhattisgarh, Goa, you must go to Mumbai office, Chennai, that this Tamil Nadu, Kerala, and Karnataka, Andhra Pradesh, New Delhi, Himachal, Haryana. So I have already given all this, so you can go by this. And these are the few case studies. So again, that I am deleting all these. I am not in a position to discuss all these case studies in detail. Otherwise, the rest part I am not able to cover. So when we talk about the trademark, this is the third part of the IP. A trademark is a visual system, see carefully, in the form of a word, a symbol, or a label applied to an article of manufacture or sale with a view to indicating to the consumer to origin of manufacture. It helps to distinguish such goods from similar goods manufactured by others in the same trade. Here the point is that, say there are so many entrepreneurs in the market, there are so many producers in the market, how they will differentiate their products from others. So in case of the differentiation of the products, they will follow the system, the trademark, that will also cover under the copyright law. I have given the 2 examples here. One is the Coca-Cola, the style, the way this Coca-Cola is written. It is a trademark of the Coca-Cola group, say the company. This is the soft drink company. The style, the way they have written it, others will not follow it. If they will copy it, they will get the punishment. Another example, very popular, say the trademark I have mentioned. Normally we pronounce it Tata, but it is not Tata. It is the T symbol. So we cannot pronounce it Tata, but it is the trademark of the Tata group of industries. Whether you find Tata car, Tata truck, Tata bus, Tata tea, Tata, say the steel, that you will find this trademark. This very important trademark. So these trademarks help the differentiation of the products from the other producers. So in India, this protection is obtained through legislation covered under the Trade and Merchandise Act 1958. And the term of protection in India, it is 10 years, but it is renewable. So after 10 years, it is renewed further for 10 years, then further for 10 years. So it is also having the legal implications to differentiate the product. If you will use the name of the other producer's product or style of the other producer's product, that will also be covered under the copyright law, and concerned person will get the punishment. Very interesting case study I will cover within 2 minutes. Very interesting case study. This is the government to fight for Khadi trademark. So all we know Khadi very important during the this freedom time, when there was the freedom struggle in India against the Britishers, that this Khadi was used, and Khadi was very important. But what Germany's companies did, that they used the Khadi trademark and they manufactured, say, the products like shampoo, soaps, kajal, and lipsticks, and they used the term Khadi. They used the trademark Khadi. So Indian community purchased this khadi trademark with the hope that these are the products which are produced by Indians and we should promote these products. But when they came to know that, okay, these are the products which are not produced by Indian firms, these are produced by the German firms, they complained, and government of India went against this, and government of India asked that it is a very popular trademark, this khadi in India, and that was used during the freedom struggle, and it was vacated. Immediately, Bangladesh and Pakistan, they also claimed, they said at that time, we also cooperated. And during the freedom struggle, India was one, there was no Bangladesh, there was no Pakistan. So the predecessors of these two countries, they also claimed that, okay, we will use this khadi for our products, and they did also, because it is a fact also. So it is not so simple, it is very tough exercise. How will deal all these IPR laws? So this is the indigo that I am, that another case study, if you see the this logo, you are aware about the AAP party, that this is literally the logo of the Aam Aadmi Party that was developed by Sunil from Bihar. That time he joined this AAP party, but he left the AAP party due to some differences with Mr. Kejriwal, and now he is saying that this is my intellectual property and I am not allowing the party to use my intellectual property. Now both went in the court, the party also and Sunil also. What will be the decision of the court will be, that is the different side. But what I mean to say you quickly, that it means that these are so serious things that these are having the legal implications. So we are talking minor, but these are very important aspects. Then the next type of the IPRs, this is known as industrial design. In a very simple way, industrial design protects the aesthetic aspects, shape, texture, pattern, color of a product rather than the technical features. It means that will cover the aesthetic aspects of the product, and most importantly, the type of the machine, the type of the technology the product is having. We will not bother about that. We will bother only of the aesthetic aspects, the outside aspects of the product, that what is the shape of the product, what is the color of the product, what is the size of the product, that we will see this. So for example, if you see Maruti car, that only to see the outer look you can identify the name of the manufacturer. Tata cars, only to see the outer look you may identify the name of the manufacturer. BMW, only to see the outer look you can identify the name of the manufacturer. Inner side, the type of the technology they have used, that will not cover under the industrial design. That will cover only the outer look of the product. This is the industrial design. It means that a person who will develop the outer look of the product, then this will be covered under the industrial design, and again that will be registered. It must be an original design. It must not have been published in India prior to the date of registration. So after it will be registered, then that will become the legal claim of the company who will register in its own name. So this is the industrial design. In fact, so I have given you the two examples, that two cars, the model of the two cars, that how these two cars are appearing, what is the look of these two cars, and only to see this that you can identify the name of the manufacturers. This is the industrial design. You know that here I am giving you one small example, because when we try to link with the this product, say you are having laptop with you because you are watching all these things, that in the laptop the machine we are using, hardware we are using, that will go to the patent law. The protection will be given by the patent law, because inventions and innovations to this hardware, that will be covered under the patent law. The software that we are using, that will be covered under the copyright law. Then the outer look of the product, that will go under the industrial design. And some logo, say if you find Apple, that will find the logo, that will be covered under the trademark. So how these laws are working in case of the entrepreneurs. Another important side is that it doesn't mean that the entrepreneurs will study these IPR laws and will get the diploma. No, there is no need, because nowadays in the market you are having the attorneys. So they can hire the attorneys who are having the specialist in the IPR laws, and then they will give all the details. They will tell the implications of these laws, so that the entrepreneurs must take the issues raised by the IPR, so that their business may be flourished. So next part, the next type of the IPR, that is the geographical indications. Geographical indications identify a good as originating from a territory, a region, or a locality where a given quality, reputation, or other characteristics of the good is essentially attributable to its geographical origin. So very importantly, that some products are having the quality due to their locality. So for example, if you take Allahabad, Amrud, Allahabad, guava, then you may have the guava here, but the taste of this Allahabad guava is specific. That is only due to the locality. That is only due to the geographical regions. If you take the plant from the Allahabad and bring in Kurukshetra or in your place, and if you grow it, then the taste of the guava will not be the same as Allahabad. That is due to the climatic conditions. Similarly, if you see the Banarasi sadhi, then we are having so many examples. I have given here so many examples. The taste is only due to the geographic regions, not due to some other regions. So this will come under the GI. The office is in Chennai, so I have given the say here the some examples like champagne. This is the Scotch whiskey also. These are produced say in the UK, in a particular area, the Scotland, and the taste is different. If we are having the whiskey in India also, but the taste may not be different. That and when you see the Indian examples, basmati rice, Assam Darjeeling tea, Kanchipuram sari, Kolhapuri sari, Kashmiri shawl, Banarsi sari, all will be covered under the geographical indications. The most important part of this type of the IPR is that it is a community right. It will not go in the name of the individual. It means that here producers, they will form a group, and the group will get the GI. Because if we talk about the Banarasi sari, in Banaras there are the thousands of the persons who are manufacturing these sarees. So a simple person may not say that I will be benefited. No, the whole group will be benefited. Suppose in a particular area, suppose in Haryana, if we talk about the basmati rice, that the farmers, they are producing, so the GI benefit will go to the whole farming community, not to a particular farmer. So here the point that we may remember, this is it is a community right basically. Then we have the trade secrets, the undisclosed information. So undisclosed information refers to trade secrets or know-how that has commercial value because it is secret and that has been subjected to reasonable steps to keep it secret. The TRIPS agreement stipulates that a person lawfully in control of such information must have the possibility of preventing it from being disclosed, acquired by, or used by others without his or her consent in a manner contrary to honest commercial practices. So here I have put two examples. One is the Coca-Cola concentrate and another is the fish treatment for asthma. Coca-Cola concentrate, that it has the specific taste because it has the combination of the concentrate in the different manner. If it is opened, that we can say they prepare this by using the concentrate at our home also, and the business of the Coca-Cola, that will be disturbed immediately. So even under the IPR, when we talk about the IPR laws are also exception from the RTI Act also, that nobody can ask the information, can force the producer to get such type of information through the RTI law also. So Coca-Cola concentrate, this is the example, and here I'm telling you one proverb that in USA, because it's a US-based company, in USA there are only two persons who know the full concentrate, half one, half other, and it is also a proverb that two persons may not travel together in one plane. The reasons may be the company knows best, but this is the proverb. Fish treatment for asthma. Another example that in Hyderabad there is a family, and this family is providing the treatment of the asthma patients through the fish. Normally people take fish and invest in the Silchar, it is very popular, but the family is providing the treatment to the patients by the fish, and a particular family knows this art and they are not disclosing it. That is why they are having the business. Here the point is, the moment they will say that tell it others, that the business will over immediately. So they will not disclose it. due to the secrecy. So secrecy will be maintained and there will be the trade. If they will open the secrecy, then trade will over immediately. That will cover under the undisclosed information. That the last law, here I am skipping this deliberately. The last law, this is the layout designs of integrated circuits, that normally the persons who are having the specialized electronic goods also, say for example, if I am using the computer, the laptop, that these are having the circuit, so that will be covered under the copyright law. And this law was introduced in 1989 in our country, and this Department of Industry, this all these law come under this side. So electronic goods, that also fall under the copyright law. So these are the same laws. And now I very quickly am covering the third part of my presentation. This is the relevance of IPR. So the relevance of the IPR, that why we are discussing this topic, it has some relevance. Where here the case study, the entrepreneurs. So how the entrepreneurs will be benefited by these laws. So I have simply explained the laws, what is the concept of IPR, and what are the forms of IPR in such a simple manner, so that the persons may easily understand what is the IPR and what are these various forms of the IPR and how these forms will affect the business. So now, what is the relevance? The progress and well-being of a humanity rests on its capacity to invent and innovate. Yes, if we wish to join developed economies, that there is no way other than to develop inventions and innovations. Our producers, our manufacturers are not capable to face the international competition, global competition, due to the lack of inventions and innovations. So if we wish to develop our economy, we must have more and more inventions and innovations, and patent law is giving the protection to the new inventions and the innovations. Say, for example, in case of the defense, recently we purchased 5 Rafale, say the planes, and we are boasting of that we have 5 Rafale. But if the are we capable to give only to go for repair of these planes? No. Again, we will invite such of the companies who can do that. So we are talking about such a thing. So we must be capable. We should have inventions and innovations so that we can develop our economy and we may get Atmanirbhar self-dependence in terms of the technology, in terms of the inventions and innovations. We must have our own technology, so we can reduce our dependency on other countries. Individuals and institutions invest time, effort, and money in inventions and innovations. Yes, when individuals and institutions, as I have quoted the example that our institute is bearing all the expenses which are incurred to get the patents, then institutions also investing, individuals are also investing this money, individuals are also doing the effort. So the result should be positive, that they should convert these inventions and innovations into the product. So when the inventions and innovations will be converted to the service and the products, that will come through the entrepreneurship. So one side, develop the this, get more and more patents, but we have the innovations that may be commercialized. And who will commercialize the innovations, inventions? Entrepreneurs will do this job. So that is why we are having the linkage. So Dr. Saurabh, in a very cunning way, in a very intelligent way, has combined these two things, IPRs and innovations. So these innovations may be converted into the goods and services through the entrepreneurs. So this is the idea, in fact, basically, to frame this course and all that side. So the participants may agree with me that why Dr. Saurabh has done this job. He has done this job by keeping these things in the mind, that more and more inventions will come, more and more innovations will come through the persons, through the institutions, and these inventions and these innovations must be converted into the goods and the services. And who will convert these into the goods and services? Entrepreneurs. So this is the idea, IPRs and entrepreneurs. By rewarding inventions and innovations, IPR encourages creativity. Yes, when patent holders will get their remuneration, their profit, and that will again The mind will work, and the person will try to go for more and more innovations, because will be encouraged by creativity. And the most important thing, that will get the money also, will become the rich person also by applying the mind. So there is no need to go say to start the other things, that if very intelligent person, if it's a very fertile mind, a very creative person may earn huge money through this system. IP protection spurs international trade. So this is a very important point, why it is important that we may not able to develop our economy without commanding in the international trading. International trading, very simple to say, imports, exports, but how it is possible to enhance the exports and to reduce the imports, the very, very important part. And that will be possible only when our manufacturers will be will be competitive in terms of the innovation. When our institutions, when will provide the competitive technologies to these manufacturers, and by using these technologies, when our manufacturers will convert into the service and the goods, that we may able to reduce the imports and we may able to enhance the exports. So this is the important part, that why we require this international trading for the development side. If we take in very quickly, if you take the example of the Japan, during the Second World, Japanese economy was completely destroyed by USA. But after that, if you see the recovery of the Japan, that they achieved all these, a very small country in comparison of India, but they have achieved all these things only through the inventions and innovations. Nobody can deny this fact worldwide. It is a hard fact. The IP system helps strike a balance between the interests of the innovator and the society. So interest of the innovator, that will be fulfilled. We will get the name also, fame also, money also, and the society will get the new goods and the new products also. So what I mean to say, that what is the relevance of the IPRs? The relevance of the IPRs is that when we will do more, so we will file more patents also. When is the literary and artistic work, if you are giving our original writing also, if our research papers are based on our original thinking also, that will give the name and fame to the individual, to the institution, and to the whole country, and then we will get the respect in the whole world. This is the idea actually behind this, and this idea we can mature only by following the IPR laws. And now, without following the IPR laws, we will not able to achieve our targets. This is the most important, individually also, and at the level of the institution also, and at the level of the country also. So I have covered these three important issues in little quickly. But anyhow, that I think that this I have conveyed the message to all the participants, and I will take 2 or 3 minutes to wind up. Then I will take the questions. So if is the history of IPR in India, first law came in 1856. This is some interest that will add your knowledge. And then, because that was pre-independence period, we were under the rule of the Britishers. So then 1859, 72, 83, 88, 1911, these amendments will take place. In 1920, 30, 45 amendments to the 1911 Act. This was the Industrial Act. These amendments were made. And if is the post-independence, that 1952, 53, 70, 1995 to 2005. So these amendments were made under the these instructions of the WTO, and we have followed all the obligations of the WTO. So presently we are having the full-fledged IPR system in our country, and these are the laws before the this WTO patent, copyright, trademark, industry. These were the 4 laws before the WTO agreement, and after the WTO agreement, 3 more laws were also added: geographical indications, layout designs of integrated circuits, protection of undisclosed information. So presently we are having these laws in our country. This patents, copyright, trademarks, design, geographical indications, layout design of integrated circuits, protection of undisclosed information, new plant varieties. So that's all about my presentation. Thank you very much for giving me this opportunities. The objective that I will not discuss this. So thank you very much.
Thank you very much, sir.
Okay, sir.
Stop your presentation, sir, so that we can move ahead.
Okay. Okay, okay, okay.
Please, sir. Thank you very much, sir, for delivering such an interesting and informative session on concept, relevance, and forms of IPR. Sir, I am happy to inform you that at on average, more than 300 participants are watching the live telecast of this workshop on our official YouTube channel. So from the comment section of the YouTube, I'm happy to inform you that the participants kept on saying that one of the best sessions they have here on this workshop, on this platform, on the basics of IPR, sir. You have wonderfully managed the whole of the things with the latest case studies. You have clearly shown basically the importance of copyright in academics as well as to the industry. So now, sir, we are taking some of the queries of the participants. With your permission, sir.
Okay, go ahead.
Thank you, sir. Sir, I think, sir, you have not stopped the presentation, sir.
No, I have stopped the presentation.
Okay, let me check, sir.
Is it okay now?
Yes, sir. Fine, sir. Absolutely fine, sir. Sir, is the question answer slide visible to you?
Yeah.
Yes, sir. So, sir, the first question is from Manoj Kishore Pradhan, and the
Yeah.
question is: design will come under copyright or trademark or both?
No,
Kindly
that will come under only the trademark, not under the copyright.
Okay, sir. So the next question is from Muhammad Salahuddin. What is the copyright provision in the case of e-content?
Yes, e-content that the person may go through the copyright law, and all that will come under the different type of the treaties, phonogram, and all that side. So that I have not covered deliberately on this idea. But certainly we are having the separate laws for that, the cyber laws and all that side.
Yes, sir.
Entirely.
Sure, sir. Sir, the next question is from Joseph Fernandez. If a poem is published in a newspaper, can we use the same poem elsewhere?
Yes, we can do that if we are having our copyright. If it is my original, that I can do that. But we remember here one side that if you will do it again and again, that will come under the self-plagiarism. When you see the plagiarism, there is one form of the plagiarism. Quickly, I have not covered this. This is known as self-plagiarism. If I will republish my published work, that will one form of the plagiarism. Right?
Thank you, sir. So the next question is from Shraddha. What can be patented in India compared to foreign counterparts?
You know that I have told in my presentation that inventions and innovations we can patent it in our country, and we are at par with the other countries. So what are the rules and regulations in terms of patent are followed in other countries, we are also at par with other countries. But when we talk about the patent, it is a territorial right that will be applicable only within India. If we wish to go abroad, then we have to file the patent country wise. Okay, that will go for the country wise, but not the PCT, Patent Cooperation Treaty. That there are 25 countries who are the member of this treaty, and if they are the member of the PCT, that it means that if we file the patent in India, automatically that will be applicable within these 25 countries. So in case of the patent, we have to go country to country. So it doesn't mean that I have filed a patent in India and it is guaranteed in my name. Automatically it will not be applicable outside India. If I wish to apply in USA, then again I have to go to file the patent in USA, and the rules and regulations of the USA will be finalized.
Okay, sir. So the next question is from Gundlapalli Sirinisaro. Sir, I applied for a patent with provisional specification 2 years back. Shall I continue the development of the product? So in this condition, my work will be valid or not?
Yes, the work will be valid, but there is one condition. In the patent that before applying in the patent, we should not publish the work. If I will publish the work before filing the patent, then my work will not be applicable to file the patent unless. Hello.
Yes, sir. Yes, sir. Yes, sir. Please, sir.
So here the important point is that there is the condition that if I am going for the patent, then I should not publish my work. After filing the patent, I can publish my work. And if the 2 years have been completed, it means that his work should be published. Because after filing the patent, the next step will be the publication of the work. The work will be published. It means that it is under the process. And now we take the patent office in India. Now they have a speed trial system, and within 3 years they are granting the patent also. In our 2 months back, we filed one patent, and it is published in 2 months under the fast track.
Okay, sir. The next question is from Ronit Jain. How to decide between applying for a patent or keeping an invention a trade secret, since everything, including the know-how, has to be disclosed for a patent?
No, in fact, that patent is entirely different, and the law, the trade secret is entirely different. Under the patent, only the inventions and innovations will be covered. But under the trade secret, that I have quoted the example. Say, for example, if we talk about the Coca-Cola concentrate, this Coca-Cola concentrate, others may not force me that you give the details of this, because under the I mentioned RTI Act, it is also prohibited that if someone will ask under the RTI Act that you give the details of your secret, I will not give the details of the secret. It is I have got this freedom through the laws under the trade secret law. So it is entirely different from the patent.
Yes. So, sir, the next question is from Dr. Narayan. Can we apply for a patent of a herbal drink with new process that may provide a solution to the asthma?
Oh, yeah, sure, we can do that. Because I have given 3 conditions. It should be new, it should not be a prior art, and it should be industrially applicable. So it should not be prior art. That is more important part. Otherwise, the person may go for the patent.
Okay, sir. So thank you very much once again.
So thank you, Saurabh.
Thank you very much, sir. Sir, on the behalf of all the participants, I would like to thank you for such creating and delivering a wonderful session on this workshop on intellectual property rights and entrepreneurship development. Thank you very much, sir. Sir, we are immensely, you can say, honored to have you here, sir. So thank you very much, sir.
So I wish a great success for this course.
Thank you very much, sir. Thanks a lot.
God bless you.
Thank you very much, sir. Namaskar. So participants, now we are moving ahead. We are having with us Dr. Sunil Kumar Yadav. Dr. Sunil, are we audible to you?
Yes, good evening, Dr. Saurabh. You are audible.
Good evening, Dr. Yadav. So, Dr. Yadav, on behalf of the organizing committee of 1 week online workshop on intellectual property rights and entrepreneurship development, I welcome you.
Thank you.
Dr. Sunil Kumar Yadav is a science graduate from Delhi University, Master in Business Administration from GGSIP University, Delhi, and PhD from NIT Kurukshetra in the domain of intellectual property rights. He analyzed the performance of Indian pharmaceutical firms in the IP regime. He has worked at managerial level with leading pharmaceutical companies like Panacea Biotech Limited, Pfizer. He has successfully built brands like Nezatox and Alterine. Flair to embrace challenging position drives him towards String Systems, an IT company which deals in developing customized software and e-learning suites. Simultaneously, he started teaching economics and marketing in the part-time MBA program. Later, he chooses teaching as a full-time profession. Currently, he is working as an assistant professor at Rukmani Devi Institute of Advanced Studies, New Delhi, which is affiliated to Guru Gobind Singh Indraprasth University, Delhi. He has delivered a number of expert talks on intellectual property rights and related area of interest. He has conducted and attended a number of workshops on international conferences in the domain of intellectual property rights. He has also published a number of research papers in the Journal of National and International Repute. Presently, he is acting as a co-investigator of a research project on IPR and entrepreneurship funded by the Department of Science and Technology. The today's topic of Dr. Sunil Kumar Yadav is international agreements on IPR and cases related to patent infringement. Dr. Yadav, we are blessed to have you as one of the experts of this workshop on intellectual property rights and entrepreneurship development. Kindly enlighten the participants with your words of wisdom, sir. Sir, over to you, Dr. Yadav.
Thank you, Dr. Saurabh, for introducing me to the audience. I hope I am visible and audible to everybody.
Yes, sir, absolutely, sir.
Okay, so before the start of the session, I would like to thank the organizers for IPRED for giving me an opportunity to share my experience and my viewpoint on intellectual property right. This time I have been given a responsibility to discuss few treaties, IPR related laws and treaties which were held in the past. And these treaties, because they are the base of what the IP regime which we see nowadays, so they are very important to understand. So I will be going slowly and steadily to build an environment where we will talk about what the present IP environment of India. And I definitely agree with Dr. Saurabh Verma with the theme which he has given to this workshop, that there is a strong linkage between intellectual property right and entrepreneurship development. I do believe that even in the country like India, right now, out of 100 enterprise which starts, around 8 or 10 hardly they survive because they don't have element of innovation in them. They all work on Me Too kind of products. They don't innovate. And the angel investors, when we talk about, or when we talk about the customers, they always search for new. So IP creation, IP generation will definitely build strong businesses. And when we create intellectual capital in our own organization, we could able to sell it at a very high pace and the success rate increases. Even if we don't want to sell the products, we can even license, outsource, as Dr. Rajendra Deshwal sir has given an insight into the basics of intellectual property rights, its role and relevance. And he has rightly mentioned that these intellectual property rights are having a strong importance nowadays in this contemporary world. So by this note, I start my presentation, and I will be dealing with the technical aspect of it, how this intellectual property has evolved over a period of time. Dr. Saurabh Verma, please tell me if my PPT slide is visible to everyone. I am sharing it. And yes.
Yes, absolutely visible, sir. Sir, please go ahead.
Okay, thank you. If I have some issues, or can say if you find some issues because I may not able to know the internet connectivity during my presentation, kindly do inform me so that I may reconnect it with the audience. Yeah, because sure. in this era, we are having a lot of challenge because we are at our home and sometimes internet may become a constraint for us. Okay.
Sure.
So dear participants, one disclaimer, one disclosure from my side that I am not a patent attorney. I am just a student of international business, and I will share what I have gained in the last decade, 10 years or so, in the domain of intellectual property right. I learned few things related to intellectual property right when I was doing my PhD. Yes, this domain appeals me because I worked with pharmaceutical companies when I started my career, and pharmaceutical companies were the companies, those who face a lot of threat when it comes to Indian pharmaceutical companies. So I may be touching upon my practical experience. I will try to connect it with the latest examples as well, and then we will try to collate and we'll come up with some concrete outcome of what this international agreement on IPR in the cases related to patent infringement. So my presentation will be divided into 4 parts. First of all, I will be dealing with international treaties and conventions which were happened in the past, which led to the foundation, which built the foundation of the present IP environment and the legislation surrounded. Then I will be dealing with an introduction of TRIPS agreement. Selected articles of TRIPS agreement will be discussed in this presentation, where we will see most relevant articles of TRIPS agreement, I would like to say, which will definitely have a strong impact on India. I will be talking from the context of Indian business. So later on, I will be discussing the third part of my presentation will take care of the Indian Patent Amendment Act 2005. Indian Patent Act was introduced in the year 1970, as Professor Rajendra Deswal has already mentioned, and he made my path easy. So Indian Patent Act was introduced in the year 1970, and then later on, when WTO comes into being, we have to modify our Patent Act. It was modified 3 times in 1999, 2003, and 2005. So amendment we will be discussing. What are the major changes which take place in the Indian Patent Act and what are the consequences of that? And then second, the last component will be on the cases of patent infringement in India. So when we say the patent infringement in India, that means I will be talking about the post-TRIPS scenario. That means after 2005, there started the series of litigation on Indian companies, and I will be taking the emphasis will be on the pharmaceutical firms because they are the most affected industries. So I will be taking 4 or 5 cases of Indian pharmaceutical firm where the infringement case has been levied on India, and sometimes we won the case, sometimes we lose. So that has shaped the environment, you will say IP environment of the country. So to start with, I will start with the Paris Convention. We today, in the year 2020, we are discussing that IP is relevant, IP is contemporary. And we are saying that we are in a belief that intellectual property rights are very new, but it is not like that. Even when we talk about the Paris Convention, it's 1843, but it has its origin way back in 1400, and so where exclusivity has been granted to the people. But I'm not going into the detail of that, from where it has started. But I will start from the documented process, documented way, where the Paris Convention of 1883 was started for the protection of industrial property. Broadly classifying that IP is broadly classified into 2. One is industrial property, and other is the copyright and related rights. So this convention was adopted on March 1883 in Paris and subsequently revised in Brussels in 1900, then Washington in 1911, then in 1925, then 1934. Amendments takes place, and the last amendment was in the year 1979. So what this industrial property talks about? The industrial property protects patents, utility models, industrial designs, trademarks, service marks, trade names, and indication of source of origin of a particular product, which may be later on called as a geographical indication, where we talk about the source of origin of a product. It guarantees to all nations of any country of the Union the basic right, which is known as right of national treatment. I will be trying to explain it in a more better way, so that we could able to understand the concept better. So let us understand what is the national treatment is. National treatment means we are giving equitable treatment to the innovative outcome of any states or countries. That means if the innovation comes from India and the innovation comes from America, I will give an equal weightage to the innovation, whether they are filing in India or the Indians are filing in American, but they are treated equally. Then we talk about right to priority. As we have discussed, that Paris Convention, it started with 14 members, then the members increased. That means we are talking about the convention countries. That means the countries, those who are member to the Paris Convention. So once we go for international filing procedure, as Professor Rajendra Deswal was discussing, that we were talking about international filing, PCT application, then we talk about convention applications. And so when we go for convention application, that means international filing of patent, we are granted a priority. So this Paris Convention states the period of priority. Priority means you file in the country, let us say I file my patent in India as an international filing, and I quoted that I will file my patent in all the convention countries. So I will be given 12 months to file my patents in those countries. So the priority date has been set so that no one other can file the same patent in his country or in different part of the world. So this Paris Convention gives a priority date of 12 months for patents and utility models, and 6 months for industrial design and trademarks. Some common rule for members are being set by the Paris Convention, and we must understand it before we getting into the complexity of it. The patent granted for same invention in different contracting states are independent of each other. As Dr. Rajendra Deswal was also highlighting, that it is a territorial right, right? So wherever you are filing, you have to file it separately, and the we can say the inspection or any granting procedures and all will be independent of what you have filed. Maybe your patent is being granted in Germany, but it may not be granted in India. Maybe we have some more different legislations. So we cannot oblige other contracting state to grant the patent because the patent has been granted in Germany. Each country shall have a right to make legislative measures to grant a compulsory license. Now, let us understand what compulsory license is and what is the significance of compulsory license. Compulsory license is the license which is issued without the consent of the innovator to the third party in certain circumstances. Circumstances may be that the patent is not worked in. That means the person who is holding the patent, he is not exploiting the patent, and he is having a full control of it, and that is not available to majority of the people. In certain emergency, extreme emergency cases, government go for a compulsory license, and in some other cases as well, we will talk in detail later. So compulsory license is the license granted by the government to the third party even without the consent of the right owners. That means the patent owners. Then compulsory license can be granted only after 4 years from the date of filing and 3 years from the date of grant, whatever expires last. So we can say that yes, definitely the innovator is providing exclusivity for at least 3 years. After that, any party can, through proper channel, can ask for licensing, or you can say for, getting, license to use a product. So forfeiture can be granted only in the case where compulsory license is not sufficient to prevent the abuse. That means we can forfeit even the patent, even when we don't able to find the compulsory license sufficient for that. We will discuss all those things in detail. Okay. Yes. Industrial design must be protected and may not be forfeited either by reasons of failure to work or by the reason of importation of article corresponding to those that are protected. Very important component that we must understand, that we cannot reject or we cannot cancel the patent, the granted patent of any innovator, only on the basis that it is not manufacturing in my country, they are just importing. So initially, when I will talk about the Indian Patent Act, we will say that initially when it was not amended, so the Indian Patent Act of 1980 talks about that sorry, Indian Patent Act of 1970 talks about that, if the patent is not manufactured or worked in the country, we cannot grant them. So we have to understand this from that point. Marks, when registered in the country of union, shall be regarded as independent of marks registered in other countries. Same happens with the patents and utility models. Same is with mark. But the trademarks, they are protected automatically even if they are not registered in the country. The well-known marks are registered or they are protected in any part of the world. So each contracting state must provide an effective protection against unfair competition. That means there should not be such kind of thing where the people infringe the patent, and we must have a legislative framework to protect the innovation of the people. Berne Convention, now coming up to the, when we talk about Paris Convention, that was related to industrial property. Now we are talking about the Berne Convention, which is related to the copyright. That means it will be dealing with literary and artistic work. In 1886, the Berne Convention for the protection of literary and artistic work comes into existence. The aim of the convention is to protect the right of the authors in literary and artistic work. The aim behind the convention is to protect the right of authors, their literary and artistic work. So now we need to protect the literary and artistic work of the authors, maybe in the form of books, maybe in the form of any picture, image, sculpture, drama, several other things we are talking about. So Berne Convention is also based on two basic principles. We talk about national treatment. When we say national treatment, we are saying on the same line which Paris Convention was talking about, that we should provide an equal treatment to the works originating from any member states. And second is automatic protection. Here I would like to quote one thing, that when we talk about copyright, copyright gets its automatic protection once it is published or visible to the public. But we have to keep the record so that we have to, we could able to produce it in case of infringement, that this copyright work belongs to me and this was published in this particular journal, magazine or so that I get a protection to that copyright, otherwise it may be an infringement. Berne Convention also obliges states to provide authors of literary and artistic work rights, which include right to reproduce, right to translate, right to broadcast, right to perform in public the dramatic and dramatic or musical works, right to recite in the public the literary work, and right to use their work as a base for audiovisual work. So Berne Convention, gives, permits, or you can say asks the member states to provide these kind of rights to the authors. Now, these are the basic rights of copyright. Now we are talking about the more deeper insight into it when we talk about the neighboring rights, like the rights related to performers, phonogram producers, or broadcasting organization. So let us understand it in that way, that I am a producer of a film, I produce the film, a writer writes a song for me, and a singer sings for it. And then they are contacted, or the song is being created for that particular movie, and the lyricist and the singer was consented for that, yes, this song is for the movie. But what will happen if the producer of that movie extract the song and give it to the third party in lieu of some monetary interest, and ask him to go for a remix? In that case, we need to protect the performance, or you can say protect the neighboring rights of performers, producers of phonograms, and broadcasting organization. That led to the evolution of Rome Convention. This convention obligates contracting states to protect the performance of performers. Like, suppose I am a dancer, I give my performance in a particular ceremony in a particular area, and now my dance is for that particular, I have given a consent for display for that particular performance. But if somebody copies it and then he put it in some other website or so, and then he tried to fetch revenue out of it, then I can stop him. This is what we are talking about. The convention protects performers against certain act that they have not consented with relation to the broadcasting and communication with the public, their live performance. So for the things they have given a consent, it is okay. For the thing they have not given the consent, they have a right to protect, or they can ask the remuneration which the broadcasting organization or broadcaster or any other which is making a multiple copy of it is generating. Then we talk about Patent Law Treaty 2000. This Patent Law Treaty was adopted on June 2000 in Geneva and entered into force in 2005. It was adopted to harmonize, streamline the procedure to make it more user-friendly. So Patent Law Treaty was come into force to make the filing of a patent harmonized and to implement a easy way to file. And the easy way to file the patent is maybe with the help of Patent Cooperation Treaty, PCT route. When we talk about PCT, we are talking about the treaty between the member states where we can file simultaneous patent in the different part of the world, the country, those who are under PCT. That means they are in consensus with, yes, they are together. The Patent Law Treaty thus simplifies the process of international patent filing, as Patent Law Treaty makes it easier to receive the filing date for the patent application, reduce the requirement of the patent application, because besides filing simultaneous patent in different part of the world, we can file a single application, and whenever we are going for the country, we can refer that and then we can go for that. Give a framework for digital patent application. Online applications can be filed, and government is providing 10% rebate on that. Now coming up to the Budapest Treaty of 1977. So the treaty comes into force in 1977 and was amended in 1980. This is a very important treaty which was offered for the member countries of Paris Convention, and that was related with the deposit of microorganisms. Now microorganisms are living organisms which are you can say artificially manufactured, and this microorganism, like any other patent, they cannot be put on paper, they have to be produced. So there has to be certain depositories. So this Budapest Treaty allows member countries to deposit their microorganism in international depository authorities, and these international depository authorities, after verifying the microorganism, give a certificate of approval to the innovator, and this innovator, while filing their patent applications in their any convention country or in their domestic country, can refer that this is what has been deposited over there. So microorganisms represent all biological material, and presently here we have 44 such authorities throughout the world. India also has a international depository. India is also an international depository authority, and we are having a depository over here. So anywhere in the world we can deposit our microorganism, we will get a proof of it, and we can produce it at the time of filing. So Budapest Treaty takes care of it. International Convention for the Protection of New Plant Variety of Plant, we talk about OPOV, and as Dr. Rajendra Deswal was also talking about, the protection of plant variety. So that was the convention in the year 1961. It states that each contracting party shall grant the protection to the breeder's right. Now what we are talking about the protection of farmers' right, and we are talking about, we consider them as a breeder because they are involved in innovating activities and they are coming up with new plant varieties. PPVFR, Protection of Plant Varieties and Farmers Act, is applicable in India, as Dr. Rajendra Deswal was also discussing in his PPT. It is applicable to all plant genera and species. The condition for protection requires a variety to be new, distinct, uniform, and stable. So there are 4 conditions for that, on the basis of which we grant the protection to the breeders, the new plant variety of the breeders. Now let us understand what is new, what is distinct, uniform and stable. So when we say that the variety is new, it means at the date of filing of application for breeders' right, harvesting material has not been sold or disposed of to others. That means it is not disclosed to anywhere, to anyone, and it is not been sold to anybody. That means it is under a closed compartment of the breeder, maybe in his fields itself. Second point is distinct. It is distinct when it is clearly distinguishable from any other variety. That means it should be visible. It has a visible difference among other varieties which are available, and it is not known to the common people. Then the variety is deemed to be uniform. When we talk about uniform, it is sufficiently uniform in its relevant characteristics. That means if we are talking about the, you can say the wheat, if you are talking about the wheat, then the size of wheat should be uniform. That means if we are talking about the height of the plant, we are talking about the seed, we are talking about the quality of seed, it should be uniform. If we saw the seed again and again, and the variety is deemed to be stable if its relevant characteristics remain unchanged after repeated propagation at the end of the each cycle. So it should be new, distinct, uniform and stable. Now coming up to another important organization, another arm of United Nations, which is WIPO. So we have talked about certain conventions. We talk about Bern Convention, we talk about Paris Convention, we talked about Budapest Treaty, we talked about Patent Cooperation Treaty, we talked about patent laws and all. So now we have moved from one step from there. So now we are in a process of formulating a established institution, a branch which will take care of intellectual property. So WIPO stands for World Intellectual Property Organization, and it is headquarters in Geneva. So WIPO was established by the convention signed at Stockholm on July 14, 1967, and it entered into force in 1970. So it started functioning from the year 1970. But what it does? So WIPO is responsible for the promotion of the protection of intellectual property throughout the world. So the objective is to promote and to protect and to even to resolve disputes among the member states, private disputes among the member states. If certain dispute arises, it will come into action and it will try to negotiate and try to make a harmonious environment. So it also administered various multilateral treaties dealing with legal and administrative aspects of intellectual property. That means WIPO's prime role is to harmonize the IP environment and to resolve the dispute if some kind of dispute arises between the member states. Okay, but how this WIPO comes into existence? WIPO has its roots from Bern and Paris Convention itself. Now let us understand. So 14 member states of Paris Convention set up an international bureau to carry out administrative tasks such as organizing meeting to the member states. So these Paris Convention and Bern Convention, they separately form an bureau. The bureau which take care of the administrative work of Paris Convention. That means the member countries, those who are of Paris Convention and the Bern Convention. So whatever administrative task, that means they are taking care of arranging meetings with the member, they are taking care of any administrative work which is related with Paris and Bern Convention. Later on, this bureau was placed under the supervision of Swiss federal government, and in 1893, these two bureaus united to form an international organization called United International Bureau for the Protection of Intellectual Property. So we talk about the bureau, and then these bureau they unite and form one organization which was known by the name of United International Bureau for the Protection of Intellectual Property, which is known as BIRP. This BIRP later on led to the formation of WIPO. That means WIPO is the successor of BIRP. As we know that WTO is the successor of GATT. I'm not going into the detail of that, but we can say that initially it was, the theme was to form International Trade Organization. Because the member countries do not get into consensus, the provisional body was formed. The provisional body was by the name of GATT, General Agreement on Tariffs and Trade. And with several rounds of negotiations, the last round, Uruguay round, led to the formation of WTO, not ITO, but WTO, World Trade Organization. We will talk in detail. Yes. So tasks performed by WIPO. The WIPO take care to harmonize national intellectual property legislation and procedures, provide services for international applications for industrial property rights, exchange intellectual property information, provide legal and technical assistance to the developing and other countries. Even when we talk about in the recent development, it was seen that it was said that if the member countries of WTO could not able to harmonize their patent law as per the international norm, WIPO may, consult them, provide their consultancy and help them to integrate with the world economy in terms of intellectual property. So WIPO help these developing countries and other countries as well to, by providing the legal and technical assistance. So this is what we are talking about, and it facilitates in resolving private intellectual disputes as well. Now, another aspect comes into being. The first thing which is there is like, okay, I have started producing my, innovating outputs. I am having patents. My country is having patent. People are having patent. They're coming up with innovative products. But how could I come to know that the same kind of product is available in the different part of the world? Or how we should able to recognize that my product is new and it is not infringing someone's innovative product which is already disclosed? How could I, in the technical term, how could I able to know the prior art? When we say prior art, we are talking in terms of the art which is already available in the domain. That means people are aware about a particular product, right? Like when we talk about, any, pen. So if I come up with an innovative product, pen, and the pen may have certain features into it, and I say this is my innovative product. Suppose I say this pen is an innovative product. So I must have to search whether this is really innovative or it is already, in the public domain and people are aware about it. So we have to, develop a classification system. We have to develop a system where the products are classified into several groups, sections and subgroups, so that while searching for those products, we could able to see, okay, these types of products are available, these claims are already there in the market, or you can say in these products, we could not grant these claims or we could not grant this patent on the basis of prior art. So this classification system is also been designed and WIPO is taking care of that. So there are certain classifications which are available. One of them is International Patent Classification, IPC. This IP is used to classify patents and utility models. So IPC takes care of patent and utility model according to the different areas of technology in which they partake. And this IPC classification is an outcome of Strasbourg Agreement, establishes the International Patent Classification, which divides technology into 8 sections. So when we talk about patent and utility model, we are divided into 8 sections with approximately 70,000 subdivisions. So although yes, it is, we have to go when we talk in terms of botany, when we talk about laboratory sciences, we have seen everything has a classification system. Even when we talk about biology, we have plant kingdom, animal kingdom, we have a classification system. So in the same way, innovation also have a classification system, and patent and utility model under IPC has 8 sections and approximately 70,000 subdivisions. So each subdivision is denoted by a symbol consisting of Arabic numerals and letter to the Latin alphabet. The classification can be used to search document for prior art. ये prior art समझना जरूरी है क्योंकि prior art, by looking into this prior art, we could able to see whether this is an innovative product or not. So IPC is continuously revised by the IPC committee of expert, and the new edition is published every year on January 1. That means new editions are being taken care of, and the base is increasing on a yearly basis. Then we have a nice classification. This classification is for trademark and service marks. So for marks, we are having nice classification. For patents and utility model, we have IPC. This classification consists of alphabetical list with an indication of class for each goods and services. This classification consists of 34 classes of goods and 8 for services. That means for product, we are having 34 classes. For service marks, we are having 8 classes, and which includes around 11,000 items. In the same way, the updation is a continuous process, and the committee takes care of it. Then we are having a Locarno agreement. Locarno agreement takes care of industrial designs. So again, it was a diplomatic conference held in the year 1968, where all the members of Paris Conventions were invited to participate. This Locarno classification comprises a list of class of subclass, list of class and subclass. An alphabetical list of goods is constituted, which constitute an industrial design, an indication of class and subclass in which they fall. So again, we are classifying, now this time we are classifying industrial designs, right? Industrial designs as per Locarno agreement. Again, alphabetical list of goods has been constituted, and the goods which fall in that particular category are categorized and shelved in a particular domain so that we could able to search for prior art. Then we talk about Vienna classification. This Vienna classification is a hierarchical system that classifies the figurative element. Now I am talking about the figures, right? Images of marks into categories, divisions, and subsections on the basis of shape. It was established by the Vienna Agreement in 1973, and it is commonly revised by the Committee of Experts of the Vienna Union. So by the end of part 1 of my presentation, we can understand that we require some legislative framework background for developing IP environment of the world, and we have well-established system now. We are having WTO, we are having WIPO, and we are having, when we say WTO itself contains TRIPS. Although yes, WTO's prime objective is to maintain trade, harmonious trade between the member countries, and it has one branch which is related to TRIPS. So slowly and steadily we are building up an infrastructure support. So when we talk about TRIPS agreement was an outcome. So TRIPS agreement was an outcome of the Uruguay round, the 8th round, which was negotiated between the member countries of GATT. And this round started in the year 1986 and ended in 1994, which led to the formation of WTO. And it lays down the minimum standard for the protection of intellectual property, as well as the procedure and remedies for their enforcement. That means we are talking about the intellectual property and the remedies which we can be, taking care of it. Let me check the time first, and then we will move further. Let me see the time. Dr. Saurabh, how much time is left for me? Can you please help me out? Dr. Saurabh?
Yes, sir. Yes, sir.
So I am left with?
Sir, yes, definitely, sir.
Okay,
so
sufficient.
Yeah.
Okay. So coming up to the second part, when we say trade-related aspects of intellectual property right, it was negotiated at Uruguay round 1986 to 1994. It lays down the minimum standard for the protection of intellectual property, and it established the mechanism for consultation and surveillance at the international level to ensure the compliance of domestic law related to the intellectual property of all member countries of the World Trade Organization. But what it means, basically, in the layman language, we can say that we are having some laws available in my country, and we are having some guidelines for every countries of the world. And now there comes a body, a permanent organization, which by the name of WTO. The WTO take cares of implementation of the uniform laws which were designed for the member countries, and it helps member country to modify the domestic law so that they come or they become compliant to the international norms. Why there is a need to comply to the international norm? To make a uniform way of doing business. When we say uniform way of doing business, it means that every country must have the basic or the minimum to protect the intellectual property of other member countries, because we all know that now we are not confined to our own country when it comes to trade. We are sending our product to America, America is sending their product to China, China is sending their product to Germany, Germany is sending their product to India, and we are dealing with approximately 150 countries of the world. And government is dealing separately, individuals are dealing separately, we are importing, we are exporting, wherever we are getting the product cheap, we import it. Wherever we find the market of the product, we export it. So when we are dealing in such type of transactions, we need to have a protection to our intellectual outcome. Otherwise, what will happen, when my product cross the boundaries, it will get imitated, it will get copied. And the conditions for copying is that the country in which I am importing, my product is not patented and the legal system of that country doesn't support it. If it is so, then we will fear of doing business with those countries and a dispute will arise. So to develop a harmonious relationship among the member countries, we come up with trade related aspects of intellectual property rights agreement, and all the member countries, those who sign to WTO, have to comply to the norms of TRIPS. Okay. TRIPS agreement. Now coming up to TRIPS, we will touch upon every aspects of TRIPS and then we will move towards. So TRIPS agreement is a comprehensive document which is divided into 7 parts and 73 articles. Part 1 take care of general provisions and basic principles which define. Now we must understand what TRIPS is. We are having some sort of understanding what TRIPS is, but we have a negative aspect of it. Majority of us, I'm not saying everybody, but we are not aware of what TRIPS is. TRIPS is a very beautiful document designed for growth and development. TRIPS says that it has to be a balanced growth. When we say balanced growth, we are talking in terms of developed and developing countries. That means every country should come on a common platform, and it is not possible. It is possible only when these developed countries, they share their technology to the developing world through technology transfer process. TRIPS provide a platform. TRIPS provide an assurance to these developed countries that you can transfer your technology and your technology will be protected. On the other part, it also take care of the benefit of both innovators and the users of the technology. Like if we take an example, that when we talk about innovator of the technology, we are talking about the companies, those who have invested good amount of money in innovation, and now they want handsome remuneration for their efforts which they have done. Now, on the other part, we are having the users or consumers. Consumers means general public, citizens of the country. These citizens are having a limited resources. That means they are having limited money, but they want to enjoy the benefit. So TRIPS take care to balance the interest of both parties, the innovators and the users. But as you know that when we talk about business, we always talk about profit. So when we talk about profit, we always think, oh, I don't care what is going on or how people are, arranging their money, but I am bothered about the profits which I want to earn because I have deployed huge amount of money in developing this product. Here I recommend to the audience that you should read, one article video hai, Fire in the Blood. The video which is available on YouTube, Fire in the Blood, and you could able to understand what are the consequences of protecting your intellectual property, your patented product, specifically in the case when it was HIV, human immunodeficiency virus. So HIV and AIDS is a taking thousands of people into its, people are dying and all, and they are not, the companies are not reducing the price of the product. I recommend you people to go through that video, Fire in the Blood. So part 1, take care of general provisions and basic principles. We are talking about national treatment, most favored nation treatment, provision for dealing with exhaustion, objectives, principles, and agreement. Part 2 depicts specific standard concerning several instruments of IPR protection and guidelines for the control of anti-competitive practice. This part is further divided into 8 sections, where section 5 take care of patent. We will be discuss it in detail, section 5 of this part 2. Part 3 lays down guidelines for the enforcement of intellectual property. Part 4 lay down the disciplines on the procedures and formalities required for the acquisition and maintenance of IPR. Part 5 covers criteria for transparency and provision for dispute prevention and settlement. That means how this dispute, if arises, will be settled, and what the government has to take the transparent way, and they should not be biased. Part 6 of the agreement points out the transitional arrangements for the implementation with special reference to least developed countries. And we're talking about transitional arrangements. When we talk about transitional arrangement, we are actually talking about the arrangement for technology transitions. And we are trying to move least developed countries towards developing. That means we are trying to improve their quality of life. Part 7 covers the institutional framework and final provisions for its exhaustion. We must understand that main goal of the agreement is to reduce the distortion and impediments of international trade. Because if the trade becomes smooth, we all know that why World War II happens. We know that everybody wants to capture the world and they want to sell their product. We know what East India Company used to do. And we know when East India Company traveled towards India, they gained an exclusive marketing rights to India that no other company from Britain will come. But when they come to India, they have seen that Dutch were already available in India, and they were selling. Portuguese were also there in India, and then they fight, and then they try to capture the Indian market cap. I'm not going into the detail of that. It takes into account the need for effective and adequate protection of IPR that need to be there, and the same time considering that it itself does not become a barrier to legitimate trade. When we say legitimate trade, that means the smooth flow of trade should be there, and the people should enjoy the benefit of the product which are available in the international market. So coming up to part 1, it is having Article 1 to 8, and Article 1 to 8 talks about the nature and scope of obligations. Various conventions incorporated in the form. When we talk about TRIPS agreement take care of the conventions which were happened in the past, and it has modified and even included new components which were lacking in the previous conventions. So we can say the TRIPS agreement is a modified version of the previous agreement. That means it incorporates and engulfs all those conventions, the good part of those, and it added some more to it. So Article 3 and 4 deals with the concept of non-discrimination. When we are talking about non-discrimination, that means discrimination should not be done on the basis of geography. He is American, we will not grant a patent. No, it will not happen. Any person from any country, if he file a patent, he should get an equal treatment. It is worth mentioning Article 7 of the agreement this article deals with objectives. Now we must understand, it is very important to understand what is the objective of TRIPS. The protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation, transfer and dissemination of technology, the mutual advantage of producers and users of technological knowledge, and in the manner conducive to social and economic welfare and to the balance of right and obligation. Here comes, a conflict between the innovators and the users. And if I am an innovator, I will say, yeah, I will definitely transfer my technology, but I want a good amount of money. If I am government of a least developed country, I will say, my dear friends, we don't have that much of money. Please transfer technology that is, necessity for us. And we could able to survive by using those technology. We could able to generate more employment to the people, and people will enjoy the product. But so the objective was very clear, and objective was for the benefit of both innovator and the users of the technology. Article 8 deals with the principles of TRIPS. This article is further divided into two parts. We say Article 8.1, which talks about that members may, in formality or amending their laws and regulations, adopt measures necessary to protect public health. Participants of this conference, please make a note of it. We will discuss it in detail in my later class slides. That we are talking about protecting the public health and nutrition, and to promote the public interest in the sector of vital importance for the socio-economic and technological development. Right, but we are not talking about that we are exploiting the innovators. That has to be inconsistent with the provision of TRIPS. That means the TRIPS itself gives certain flexibility to the member states when it comes to developing nations, that they can make certain changes in their law, looking into the benefit they could able to provide for the public health and nutrition to the people. Article 8.2 states that appropriate measures, provided that they are consistent with the provision of agreement, may be needed to prevent the abuse of intellectual property right by the right holder, or the resort of practices which unreasonably restrain trades. Article 8.2 of the TRIP itself says, in the hidden line it has been written, that we can practice or exercise our rights in the case when the patent holder or the innovator is not sharing his innovation to the people. That means he is trying to protect his innovation, maybe in the form of raising the price or decreasing the supply of the product to gain more benefit. So it is, it may adversely affect the international transfer of technology as well by Day-2. So it gives freedom. This is the flexibility available. The part 2 talks about the agreement, deal with standards. We are talking about Article 9 to 14. This part is divided into 7 sections. We have already discussed. Professor Rajendra Deswal has discussed about all these forms. I will not be going into the finer details of those. But yes, definitely we are talking about copyright related right, trademarks, GIs, industrial designs, patents, layout design of integrated circuits. We are talking about protection of undisclosed information. Another important aspect I was discussing when we talk about the parts of TRIPS, I was saying that we will be discussing about the section 5 of the TRIPS agreement, because that is very important. Now coming up to section 5, most important for India as well, Article 27, which deals with the patentable subject matters. So what is patentable subject matter? We must understand. The word patent has its origin from later patent, when the kings of England in the earlier times were granting privilege to the people, those who come up with some innovation. They provide them an exclusive right. And from there the patent word comes. Although all members of WTO has to abide to the norms specified by the agreement, patents are subject to the territory where it is filed. We are saying that we will accept, we will grant patent to everybody in the world who apply. That means it itself says that it is territorial in nature. If I want to, practice in India, then I have to have my patent in India. This is territorial in nature. Let us take an example. I am a designer. I designed a bangle. I am into jewelry designing, and I designed a bangle, and I filed an application for design patent in India. So it has been granted to me, but I send my product to Germany, and there it got copied. So I cannot say that, okay, I have already filed in India, why it is copied in Germany? I should get an exclusivity. No. These kind of IPs are territorial in nature. If you feel that the scope of selling of my product is in Germany also, then I must go for a simultaneous patent filing at the same time. I may get a priority date. I have to disclose that this patent will be filed or applicable in these countries, maybe the convention countries, or in countries I select separately, or the countries of the patent cooperation treaty. Para 1 of the Article 27 covers the definitional part of the patent, which states that no discrimination should be allowed between domestic and imported products. No discrimination. Import kar rahe hain, to okay. If you are producing, then it's okay. Para 2 and 3 of the states that subject to be provision, patent shall be available to any invention, whether product or process. Here, I would like to emphasize upon that in the early Patent Act of India, that means the Patent Act of 1970, we were only granting process patent, and we are not, the products are not eligible for product patent. So now the new Patent Act we talk about TRIPS emphasize that it should be provided for product as well as process. And what is the eligibility for that? It must be new, involve an inventive step, and are capable of industrial application. Article 27(2) deals with the exclusion criteria for the patent possible invention. Members may exclude from patenting their invention. We can exclude others from. That means we can go for. So what are the things which are excluded? So article states that member may exclude from patenting their invention the prevention within the territory of the commercial exploitation, which is necessary to protect order public or morality, which is not including to protect human, animal, plant life and health, or to avoid serious prejudice to the environment. So something which is excluded from patentable criteria, it is mentioned in Article 27(2). 27(3) talks about also excludes member from the grant of patent in the case of several surgical diagnostics. 27(3) talks about plant and animal other than microorganisms. Microorganisms are patentable, but plants and animals are not patentable. Basically, we are talking about non-biological and microbiological processes. Members shall provide for the protection of plant varieties through sui generis system. That means the system which is designed, and India has its PPVFR Act for protection of plant varieties. Article 28, which is related to the right conferred to the owner, the agreement gives an exclusive right to the patent holder to make him capable of stopping others. So right conferred to the owner, that means the owners have a right to stop others for the use, sale or importing of the product without the consent of the owner. So 28(1) talks about exclusive right of the owner related to both product and process, and the 28(2) gives right to the patent owner that he can assign or transfer the patent to his successor. That means he can restrict others from using, and he can, by his own will, can transfer it to anyone, even to his successors or to his family. Article 30 of the agreement gives certain exceptions of exclusive rights. What are the exceptions? Members may provide limited exceptions to the exclusive right conferred to the patent, provided that such exceptions do not unreasonably conflict with the normal exploitation of patent. That means we are now talking about exceptions of exclusive right. Now we are moving from providing exclusivity to the innovator, and now we are talking about certain exceptions are there. What are those exceptions? We are providing license to other third parties for doing trade of in the product which is already patent, and the innovator has to give it to the third party. What are those cases? Like we are talking about compulsory licensing. Compulsory licensing, is granted in certain circumstances when we talk about national emergencies or other circumstances of extreme emergencies, or in the case of public non-commercial use. That means sometimes when the patent is not worked in India or worked in the country, on the territory of the country where it is being granted, or in the case of extreme emergencies, or in the case of public non-commercial use. That means when the government is using it for their own purpose, that means maybe in the case of epidemic, pandemics, or in the case of vaccination to the people. So they are not charging anything. In that case, we can go for exceptions to exclusive rights. Article 32 gives authority to any individuals to file a judicial review. Now we are talking about the judicial review of the granted patent. We are talking in terms of like patent where we can ask for that this is already a prior art and it cannot be granted. So the patent can be revoked. There are the provisions where we talk about pre-grant and post-grant oppositions. Pre-grant opposition is when the opposition is being given after expiry of the 18 months of the patent and it is published in the journal of the patent office, and the post-grant opposition is for after the grant of the patent. Then the term of patent is uniform for product and process for 20 years from the date of filing. We must understand that in India we were having only 7 years for the process patent. Now after the modification has been done, it is uniformly 20 years from the date of filing. So TRIPS talks about those. Another very important article 34 which talks about burden of proof. So the burden of proof, if let us say I talk about, let's take a small example, very layman example, that I am having a small piece of land with me and somebody captured it. Right. So if I file a complaint against the particular person, I become a plaintiff, another become a defendant. So when we talk about the complaint I filed, the defendant has to prove that no, this land belongs to me and it doesn't belong to the plaintiff. Earlier it was that plaintiff has to produce the evidences that this piece of land or the property or the innovation belongs to me and he is an infringer. Now the defendant has to give evidences. This is what is the change which happened. Then we talk about section 7 of part 2 in the agreement deals with the protection of undisclosed information. This is what we talk about trade secrets, where Dr. Rajendra Deswal was talking about Coca-Cola, formula of Coca-Cola and all. So you can protect all those things under section 39(3). I am skipping this because of the shortage of time. Maybe I may fall short of time. Part 6 of the agreement deal with the transition agreement made for the countries for the smooth compliance of the agreement. Now a very important component. We are talking about transition agreement. That means the time when we are moving from less protected to the protected, or to the domestic patent acts to the complied patent acts. So this part of the agreement covers article 65 to 67, where article 65 deals with the transition agreement for the member countries. According to the article, every country has been provided with a transition period for 1 year. Let me explain what is this transition period is all about. On 1st January 1995, TRIPS comes into being. There are 3 classifications of the countries. Moreover, there are 2 classifications of the countries. 3, let us say, developed countries, developing countries, and least developed countries. When we talk about developed countries, this WTO agreement, we are talking about the member countries of WTO. So they have classified countries into 3 classifications: developed, developing, and least developed. When it comes to developed countries, they have to comply to the norms of WTO with effect from 1st January 1995. They were given 1 year to make the arrangement, make certain changes if required in their law. So they were given 1 year for the transition. Transition means to make an arrangement to comply themselves to the WTO agreement. When it comes to the developing countries, it is assumed that these countries, they are already having a patent laws available in their country. It is at a maybe at a developing stage. Maybe they are having a weak patent law, but yes, it is there in force. So they were given 5 years, and the least developed countries, because they may not have that legislative framework for their IP related norms, they were given 10 years. Now here comes a point that India, although it is a developing country, but it was given 5 plus 5 years. Why I am saying 5 plus 5 years? Because India, being a developing country, was given 5 years, and because product patent was not aligned, but it was not there in the Indian Patent Act of 1970. So they were given 5 more years to comply to the norm. It means that now we have to comply to the international norms by 2005. So this is what is the transition period we talk about. Article 66 and 67 deals with the transfer of technology and technological cooperation. We are talking about the developed country members, and we says that they should provide, the country should provide their enterprises an incentive to transfer the technology to the developing countries so that everybody get a good technology to use. So in the same way, we talk about Article 70, which takes up protection of existing subject matters. Agreement clearly states that the patent which were in existence before 1st January, yes, very important component. So we also talk about Article 70. Article 70 of the TRIPS agreement says the patents which are in the existence before 1995, they will cease to operate as a patent in developing world or least developed countries. They will not be granted patent. They will be considered, because initially they were not allowing them to apply for the patent, so they remain available for everybody. And this was under Article 78. Now they talk about the transition period. They talk about that if you want to file a patent after 1995, then it will be going to mailbox, and during this transition period until exhaustion of the time, let's say in the case of India it is 2005, when this mailbox will be opened, you will be provided exclusive marketing rights, EMRs. So Article 70.9 talks about exclusive marketing rights till the patent has been rejected or accepted. That means scrutinizing of the patent takes place. The company will be provided exclusive marketing rights and nobody will interfere in the business. This is how we end up our part 2. Now I am moving towards the part 3 of my presentation, where I will be now connecting the TRIPS agreement and the modifications which were done in the Indian Patent Act. So India's response to the TRIPS, we will be talking about Indian Patent Amendment Act 2005. So we say that although India responded very well to the WTO, we have made our modifications in the Patent Act in the 1999, 2002 and 2005. Still the world believes that our TRIPS, or you can say the Patent Act of India, is not aligned as per the instructions given by the TRIPS agreement. So let us understand. So what are the amendments which takes place in the year 1999? In compliance to Article 65 and 70, which was related with exclusive marketing right, the government introduced it, and now the mailbox was opened, or you can say the mailbox method was started, and the companies can file their applications, and they were stored till 2005, or when we start scrutinizing those things. So 8,500 EMR applications were received through mailbox. Only 18 EMRs were processed. The rest are bogus, and majority of them get rejected. Then we talk about the second amendment. The second amendment of the Act was done in the year 2002, which came into force in the year 2003. This amendment comes with 64 changes, and we have introduced the term of protection to 20 years. Initially, it was 7 years. Another very important component which was I'm coming back to the previous slide, that another important component which was eliminated from the Indian Patent Act was right of license. That means now initially we were having all rights to license the patented product to anyone in the country, but it was restricted. That means compulsory license, we have a restrictions on that. Another important article related to the amendment is 104A, which clarifies and it talks about the burden of proof. When I was discussing about the burden of proof, I was saying that the burden of proof lies with the plaintiff earlier, and now it lies with the defendant. So why it is so? Because we want to make the infringement a less. We should restrict infringements, and we should provide benefits to the innovators. In the same way, Article 107A and B, this section is typically known as provision for parallel import. What this parallel import is? Another important terminology. You must understand that parallel import can be expressed as the process through which member country can import patented product from the third party residing to another country that is authorized by the patentee to sell his product. ऐसे समझते हैं, let us understand it in this way. Suppose I am an innovator, I belongs to, let us say, America, and I give African country and license to produce my product at a lesser rate, or I am providing cheaper version of my product, patented product to Africa, and I am India. Now, American company is doing business with India, and Africa, the American company has given permission to African manufacturer to export the product as well. So in the case, we are having a parallel import. American company is importing to India, even the same product we can import it from African countries if that country, person, salesman, whatever, is having a permission from an originator, or you can say the original manufacturer, to sell it. Third amendment, final amendment, which takes place in the year 2005 to make the law fully compliant with the TRIPS agreement. Indian Patent Act allowed product patent in the pharmaceutical, food and chemical for the first time ever since the commencement. 2005 में ये change हुआ कि pharmaceutical, food and chemical के अंदर भी product patent was introduced. Another very important component which was introduced is section 21JA. It talks about inventive step. Section 25(1) was introduced, which talks about pre-grant opposition. Section 25(2), which talks about post-grant opposition. And another very important component which was introduced was, section 3D. So yes, let us understand what is pre-grant and post-grant opposition. Pre-grant and post-grant opposition is the opposition which can be done by any party if it is, the product is already known to the public and it is available in the public domain. So we can go for that. In the same way, we are having section 47, as it was there as the Bowler provisions in Canada and Hatch-Waxman's exemption in America. If we are, using the patented product or the machinery for experiment and teaching purpose, it is exempted. Then we talk about section 3D, where we talk about the flexibility given, which talks about the mere discovery of the new form of the known substance, which does not result in the enhancement of the known efficacy of the substance or the new use of the known substance. Basically, ऐसे समझते हैं कि section 3D was introduced for the first time in the Patent Act of India, and that says that neither the esters, ethers, polyps, metabolites, pure form particles, size, isomers, mixtures, means the related component are not patentable until unless they have an enhanced efficacy. When we talk about enhanced efficacy, it has a broad definition. That means the result which we are getting from the product should be better and enhanced. Then we talk about section 83 of the Act, ensures that the patented product is properly worked in the territory of the India. Now we are talking about the compulsory license. We are moving towards that, heading towards that particular component where we say that the product has to be properly worked and exhausted in the territory of the country. That means the product should be available. The innovator is granted a patent right and exclusivity for the product. So it is his responsibility to supply the product to all the needy people, the people those who required it. That means it has to practice it on a commercial scale to the full extent and is available to in the right quantity to the people wherever they require. Then section 84 talks about compulsory license. Compulsory license we have already discussed. Under 84, CL can be granted. Now we are talking about the conditions on which compulsory license is being granted. One is the regional requirement to the public. Then we are talking about reasonably affordable price. That means it should meet the reasonable requirement of the public. It must be available at a reasonably affordable price. And the patented invention is not worked in the territory of India. That means we are saying पैसा सही होना चाहिए, अवेलेबल होना चाहिए और वो सबके पास सप्लाई होना चाहिए, टेरिटरी में अवेलेबल होना चाहिए. In other cases, besides section 84, we are having 92, where government can practice its power in the case of national emergency or in the circumstance of extreme emergency or public non-commercial use. This is what we have discussed when we talked about TRIPS agreement. So, अब जैसे suppose pandemic situation है, corona है, virus, मतलब vaccine आएगी तो government may take, issue a compulsory license and take the medicine, or otherwise government will, is doing research and they will come up with the innovative product. Section 92, we talk about 92A, which was inserted as the 15th amendment. It gives more freedom to the applicant to get a compulsory license for exporting. Now we are talking about, when we are talking about 104A and B, we are talking about parallel imports. Now we are talking about, exporting. So section 92A gives a freedom to the Indian manufacturer to export it to the country where they are having a permission, the government is having a permission to get a product. So the government of the exporting country has already issued compulsory license of the product, and the importing country has, by notification otherwise, allowed importation of the patented pharmaceutical product from India. इसमें क्या है, इसका फायदा कहाँ आता है? The benefit of this comes in when we are sending the product to the least developed countries where people are suffering from diseases like malaria, dengue. These are the old diseases, we can say, in terms of HIV or cancer. So compulsory licensing can be, that 92A gives permission if both parties are agreeing to that. This is what is the difference between old and new Patent Act. Indian Patent Act 1970 and the Indian Patent Amendment Act 2005. Let's sum up. The Indian Patent Act 1970 grant only process patent, and 2005 Indian Patent Amendment Act 2005 grants patent to product as well as processes. The duration of patent is 7 years initially. Now it is extended to 20 years. The right of license was practiced, that is, automatic compulsory license is given without the consent of right holder. Now the compulsory license is on the merit basis, depending upon the case. No system for the protection of plant variety. Now we are having sui generis system for the protection of plant varieties. Does not allow protection to life forms. Now we protect microorganisms. Importation of drug does not qualify for working in India, so no protection. That means we have to do set up a manufacturing unit in India, and then only we have to we will be granted a patent, but it is not now. Even imported drugs are getting patented. Burden of proof earlier lies with the plaintiff. Now the burden of proof lies with the defendant. So this is what is the difference between the old Patent Act of 1970 and the new Patent Amendment Act 2005. So now it is, we believe that it is TRIPS compliant. Now moving towards the last section of my presentation which is related to the cases of patent infringement in India. And here I will be discussing about few cases. Like it is claimed that India has designed its acts in the most exhaustive form. Still, Indian companies face a lot of litigation suit concerning infringement of patented products. Within the short span of 15 years since the adoption of patent regime, a lot of infringement suits were filed in various courts of the country. India has come across few landmark decisions as well, while other is still pending in the court. Now let us understand few cases for our better understanding of what we have seen or studied or experienced in my previous slides. First case, Novartis versus Union of India and others. Now we will touch upon all the components. Now in this case, we will be talking about the mailbox system. We will be talking about the patent which were granted before 1995, and we will be dealing with section 3D of the act, which talks about the polyps, esters, or isomers of a same base component cannot be granted patent. Okay, let us understand. This case is related to the patent application, which is 1602, which was filed by Novartis in order to secure the monopoly position for 20 years for the beta crystalline form of imatinib mesylate. We are not talking about imatinib mesylate, we are talking about the beta crystalline form. That means the structural change in the imatinib mesylate, the base salt. It is worth to note that any patent which is filed before 1995 anywhere in the world is found eligible for patent in India. And in the section 5 of the article 70.8, we talked about mailbox transition system, and we have seen that Novartis had filed an application in the mailbox for beta crystalline form of imatinib mesylate. But we must understand this beta crystalline form was already the imatinib mesylate salt was already patented, and it was granted patent before 1995. Now what will happen? Since the patent was filed during the transition phase, it remains in mailbox till 2005, and Novartis gained exclusive marketing right for it, and it it gains several injunctions order to restrict other generic drug manufacturers to manufacture and market and distribute imatinib. It restricted several companies to promote, market, or distribute imatinib, due to which the price of imatinib mesylate increases from 90 rupees per 100 milligram tablet capsule to 1000 per milligram. See, you can see the difference. When we are having an exclusive right, we restrict others to use those things. In the same time, another landmark amendment, which we have seen, section 3D, where we talk about the enhanced efficacy of the known form of the substance. We talk about esters, ethers, polyps. So the result in the immediate filing of the pre-grant opposition after section 3D against Novartis patent application by Cipla and other NGOs, they argued that the patent does not bag any novelty, because it is already known to the people. Novartis had already granted the patent for imatinib in the USA in 1993. On the basis of pre-grant opposition, the controller did not grant the patent to Novartis. Novartis tried hard, and they say that this section 3D doesn't have an institutional validity when it comes to TRIPS. But Madras High Court has given a decision, and they rejected the application of Novartis when it comes to Gleevec, the beta crystalline form of the imatinib mesylate. The final decision comes on April 2003 by the Honorable Supreme Court, stating that the beta crystalline form of imatinib mesylate fails the test of the invention and the patentability criteria under section 2.1, clause J, JA of section 3 and section 3D respectively. Gleevec ko nahi mila. Okay. Then we talk about erlotinib Roche versus Cipla case. Another case which was related with the same kind of thing. Another landmark case that took place between Switzerland-based multinational company Roche and Indian generic drug manufacturer Cipla. रोश ने क्या किया? रोश ने अपना बीटा एर्लोटिनेब का जो बीटा पॉलीमॉर्फ वर्जन है एर्लोटिनेब का, which is the drug which is used for cancer treatment, it has tried to file, but the application was rejected on the basis that it is again the beta version of the erlotinib salt, which has already been granted a patent. So looking into that, Cipla filed an application. They come up with a they come up with a generic version of beta polymorph for erlotinib. So what happened? The judge says that then Roche filed a complaint against Cipla and they say they are infringing our erlotinib, product. So the judge says that the process for manufacturing beta polymorph of erlotinib hydrochloride result from recrystallization of erlotinib hydrochloride. That means the beta form of the erlotinib is made from recrystallization of the same salt. That means you have to go through the same process. Therefore, it doesn't have a novelty, element of novelty. No inventive step is there. So finally, the government rejected the application and Roche won the case, and Cipla has to, seize the manufacturing of the product and then withdraw it, the product. So this was the first case considered as the first pharmaceutical patent case which was closed after TRIPS, that means post-TRIPS. Another case, Merck versus Glenmark. Now we have two cases of cancer drugs. Now we will move towards the diabetes. So Merck and Glenmark. Glenmark is an Indian company. Merck is a multinational company. It is having a innovative product. So what happened? The issue comes in light when Glenmark has launched a generic version of sitagliptin, the patented drug of Merck in India. Merck has filed another patent application covering the phosphate form of sitagliptin. The patent application of the phosphate form of the sitagliptin, we must understand over here is that sitagliptin is the base salt, base form of the molecule, and now we are trying to, add the new patent so that we could able to generate evergreening. What evergreening means is that we are protecting our patent for a longer period of time. The patent application of the phosphate form of the sitagliptin was rejected following pre-grant opposition on the ground of section 3D. Why structural modification hai, enhanced efficacy nahi. Based on these rejections ground, Glenmark announced Zeta and Zetamet. Now they introduced Zeta and Zetamet, sitagliptin phosphate and sitagliptin. So the court rejected the appeal and court further stated that sitagliptin phosphate monohydrate cannot be prepared without the manufacturing of the active molecule sitagliptin. That means you are infringing the actual patent of Merck. So the court has not taken any stringent action against Glenmark, but they requested Glenmark to pay the attorney fees to the Merck and also asked Glenmark to liquidate and the inventory which is available in the market and seize the further production of Zeta and Zetamet. Another example, Nexavar Bayer versus Natco. This is a recent case when we talk about first compulsory license was issued by a government to Natco Pharmaceutical in the post-TRIPS period. Bayer was having an anti-cancer drug with the name of sorafenib, and which Bayer sold under the brand name of Nexavar. This Natco, what he has done, Natco after the expiration. Now we talk about the compulsory licensing clause and the articles which are there in the TRIPS agreement, and it says that after the expiration, even that was discussed in the Paris Convention, after the expiration of 3 years from the grant of the patent, Natco asked for voluntary license on the reasonable terms from Bayer, and the Bayer rejected. Bayer did not responded, and then Natco asked for the compulsory license from through Patent Controller General of the patent. So it was said that the reasonable requirement of the public has not been met. The patented products are not available to the public at a reasonable price because Bayer charges 2,80,000, and NATCO promises to supply the product at 8,880 rupees 1 month therapy. So this is what is the difference, 8,880 and 2,80,000 for 1 month therapy. And on the ground, the invention is not worked in India, and they got the compulsory license for manufacturing sorafenib. Another case, BMS versus BDR dasatinib. Based on these lines, the BDS, a company, Mumbai-based company, also tried to get the compulsory licensing from Bristol Myers Squibb, but they have done a, they have followed a wrong path. They have taken a wrong way. They asked for the voluntary license, but when the Bristol Myers Squibb asked certain questions, has certain queries, they don't respond to that. And what they have done, they have filed for compulsory license, and they directly, while replying to the mail, BDR was asked to reply certain queries raised by the innovator company, which the applicant do not flourish. Therefore, the application was rejected, as the authorities find that the process followed by BDR was not appropriate and had not acted in the good faith during the proceeding for application during the negotiation of voluntary licensing. That means you have to follow the procedure. You have to give certain time to the innovator to think, and you have to give an appropriate time. If the innovator does not respond in that particular time, then only you can go for the compulsory license. Otherwise, it is considered that you are in a hurry and you don't want to give an appropriate due respect to the innovator. So this is what my presentation is all about, and I rest my case. Dr. Saurabh Verma, it's to you. Over to you, please. Hello.
Yes, sir. Yes, sir. Thank you very much, sir, for delivering such a interesting and informative session on international agreements on IPR and cases related to patent infringement, sir. Sir, on the behalf of participants, I would like to thank you for delivering such a, you can say, the blissful thoughts on your knowledge on IPR. Sir, with your permission now, can we go for the question answer session?
Yes, definitely we can.
So, sir, I'm just sharing the screen for the question answer session. So you are supposed to read and answer to that particular question, sir.
Okay.
Sir, is the screen visible to you?
Yes, it is visible.
Thank you, sir. So, sir, the first question is asked by Mr. Lalit Agarwal. Can a patent be obtained for glove for keeping teeth strengthened if none has done earlier in past in international market?
Thank you, Lalit Agarwal ji. We are talking about the clove, and we know that it is, a old age practice to use clove to strengthen our teeth. So we cannot go for the patent of clove because it is already known to the people. As we know, the clause for patent application is it should be new, involve an inventive step, and must have an industrial application. If you file an application on these basis, the application will be rejected on the it is already a prior art. People are aware of. We have a traditional knowledge. We use this. The same thing happens when we talk about, if we ask for the patent of turmeric, we talk about the patent of antibiotic effect of neem. So we cannot go for clove in this case. Thank you.
Thank you, sir. So the next question is asked by Manoj Kishore Pradhan. Sir, please suggest some reference to enrich our knowledge on these international level laws. If any books, Dr. Sunil Yadav, you may suggest to Mr. Pradhan.
Mr. Pradhan, what I suggest to you is that besides reading books, first of all, we must go to the official sites of WIPO. We must go to the official site of WTO. Everything is available over there, and then we, to connect it with Indian context, we must visit the website of Indian Patent Office. Every data is available over there. If you will go through, you will get an ample information related to the patents. So before going or reading some books, it is better that you should visit the sites, and we will get an exact updated information from that. Definitely, there are several books which are available. Like we are having the book from Mr. Thomas. We are having several other books. But I first of all recommend that you should visit the official website like WIPO, WTO, and Indian Patents.
Yes, thank you very much, sir. Sure. Again, a question which is put up by Mr. Lalit Agarwal: is prior art search important for people who are interested in research of social sciences? Please, sir.
What type of research? I could not able to figure it out when it comes to social sciences. The question is incomplete, but let me put a point from prior art point of view, that when we talk about prior art search, we are saying that prior art is necessary because filing a patent is it's a tedious work as well as it's a costly affair. So after depositing the fees and going for scrutiny of the patent application and deploying 10-15,000 of rupees, or maybe higher if you go with PCT applications. So after a particular time, after scrutiny, your application has been rejected and you come to know that it is already in the public domain. Then you will feel bad that, oh, I lost that much of rupee. So prior art is required. When we talk about social sciences, I believe he is talking about the research paper. So if we are talking about writing research papers, definitely we should, before publishing our paper in any journal, we must go for a Turnitin check. And if the plagiarism level is very high, we know the guidelines issued by UGC, and it gives certain limitations. And if my paper is within the limitation of UGC guideline, then we should go for the publication paper. Otherwise, we should improve that paper. Thank you.
Okay, very true, sir. Mr. Fernandez is asking that I have drawn some art therapy books for special Divangjan kids. How can it be patented? So,
Mr. Fernandez, first of all, I would congratulate you that you have written some books, therapy books for special Divyajan, right? So that means the students, those Divyang basically. So I believe Divyang children you are talking about. That means you are doing good for those. So when we talk about books itself has a copyright inbuilt in them. You don't need to go for patented, but it is a copyright case. And whenever you publish it, if it is new, unique, it is already copyrighted. You don't need to go for copyright in that case. Thank you.
thank you, sir. The next question is by Mr. Arun Kumar. If one gets a patent in India, how can the same idea be patented in other countries? Without prior art search, can the other countries grant the patent for the same invention?
Okay. Arun Kumarji, here I would like to quote one thing, that patent is territorial. It is granted in the country, but when we go for prior art search, we go throughout the world. That means we are searching it whether the product is patented anywhere in the world. इसको ऐसे समझते हैं अरुण कुमार जी कि किसी कंट्री में फाइल करने के लिए, मतलब आपको अगर अपना पेटेंट फाइल करना है तो आपको कंट्री के साथ जाना पड़ेगा, लेकिन अगर आपको ये देखना है कि ये पेटेंट किसी और को नहीं है, तो जब आपकी सर्च होगी तो वो इंटरनेशनल सर्च होगी. तो अगर इंटरनेशनली वो प्रोडक्ट अवेलेबल नहीं है कहीं भी, तभी आपको किसी कंट्री की टेरिटरी में वो पेटेंट ग्रांट होगा, अदरवाइज इट फॉल्स इनटू प्रायर आर्ट. नाउ इट कम्स द केस व्हेन यू से दैट आई गॉट अ पेटेंट इन इंडिया, right, and now I want the patent in another part of the world. Now I would like to say that if you have applied for international patent, you have to see it from the perspective from the beginning, that you have applied for the international patent or you have applied for the domestic patent. So if you applied for the international patent, you have to specify the countries, and within the specified time. When we talk about PCT, it is 2 years. When it talks about convention application, it is 1 year from the date of priority. So you have to file within the specified time, otherwise it will fall into the prior art and you will not get a patent to that. एक साल पूरा होने के बाद आपको पेटेंट नहीं मिलेगा. इसी में ही मैं एक चीज डॉक्टर सौरभ आपकी परमिशन से एक चीज और ऐड करना चाहता हूँ.
Sure.
In the last session, Mr. Gundalapalli, I believe I am pronouncing it right, he has asked a question that I have applied for a patent provisional specification 2 years back, and now will I get a patent for that? Mr. Srinivas Rao, the point is, when we talk about provisional specification, we will be allowed 1 year of time to file a complete specification. If we exceed 1 year of time, my patent is already expired. So I will not be granted a patent for that. Then I have to see and again file it, a fresh application for that. Thank you.
So, sir, the next question is from Kailas Kolekar. Whether product patents for mechanical engineering products were allowed before 2005 amendment?
Yeah, definitely. Yes.
So next question is by Dr. Narayana. If I granted patent to an innovation by WIPO, then whether I will get patent rights in all the member countries of WIPO, including India, or not?
Dr. Narayan, I believe you are talking about PCT application, PCT filing. So when we talk about PCT filing, that is, we are talking about the Patent Cooperation Treaty. This is a treaty signed between the member countries. And if you go with the PCT filing and you categorically mention that these are the countries where I will be filing, definitely you will get patent. And if you include India, here is a case. When you want to file a patent if you are an Indian, and if you file a patent in the different part of the world, and you don't want to include India, then first of all, you have to file an application and inform the patent office that I am not going to file this patent in India. Kindly grant me permission to file, because I don't get, I don't feel that there is a scope of this product in my country. So give me the permission to file application. If you will not take the permission from India and you belong to India and you file, then action can be taken against you. Thank you, Saurabh.
Thank you very much, sir. So, Dr. Yadav, I would like to thank you on behalf of the participants as well. The cases you have discussed were very wonderful. You have wonderfully explained all the cases related to patent infringement. And with the help of the comment box, we can see that the participants are highly satisfied with your session, sir. So, sir, we are blessed to have you here in the 1 week workshop on intellectual property rights and entrepreneurship development. Thank you very much, sir. Thanks a lot.
Even I am blessed, and I am happy to have a wonderful audience with me. You gave me confidence and strength to discuss all those things. Thank you very much.
Thank you, sir. Sir, we are highly obliged to have you here. Thank you very much, sir.
Thank you. So, am I permitted to leave?
Yeah, absolutely. Thank you very much, sir. So, for the participants, we are just about to, you can say, share the link. So, you are supposed to mark your attendance cum feedback link for the session 4, which was just conducted by Dr. Sunil Yadav. The link will be activated for 10 minutes. There is one announcement also for all the registered participants. First of all, I would like to thank you for joining the event for today's session. Tomorrow also at the same time, 5 p.m. to 8 p.m., we will have the first session basically from Dr. Chetan Kumar. Dr. Chetan Kumar is a former advisor and chief scientist, IP Innovation and Protection Unit, Council of Scientific Industrial Research, CSIR, New Delhi. And they will be talking about introduction to international IP protection. So all of your queries related to PCT application, international filing will also be dealt basically in that particular session by Dr. Chetan Kumar. The next session for tomorrow will be conducted by Dr. B.K. Sahu. Dr. Sahu is a regional manager in NRDC. He is a manager in IPFC and WIPO Technology Innovation Support Center, NRDC, Visakhapatnam. Their talk will be on IPR and technology transfer. So tomorrow we will have a blissful session by these eminent speakers. So again, I would like to thank you for joining the event today itself. Good evening. Have a nice day. Thank you.